So as you probably know, this is our 19th annual employment seminar. It's hard to believe. We are hoping that next year for 20, we will be out in the community somewhere and can interact with you in face-to-face. We had hoped that for this year, but it didn't turn out that way. So here we go with my portion. We're starting with the rapid fire recent developments. And I'm going to be talking about leave issues, and just to our controller over there, we're going to minimize this screen for me. I don't know about the rest of you, but I can't stand staring at myself while I'm doing a presentation. All right, so my subject for my rapid fire update is leave issues. And we are going to be talking about leave in different contexts today, including the legislation and also certainly under the whole COVID section. So I tried to find some topics that were not either of those. And what I came back to is my old friend, the FMLA, because you know we love the FMLA, and I don't want it to get lost in all the discussion about COVID and accommodation and all that other stuff. So I wanted to talk about two things FMLA related, and one of them is timely in the sense that it deals with holidays. So we've got a bunch of them coming up, and for those of you who have people out on FMLA, I want to be sure you're administering and counting that time correctly. So here's just one short tip. If you have, let's say somebody's out on a long-term FMLA, so they're out on, let's say, the whole 3 months, and it's not intermittent. If they are out for the entire work week and the work week has a holiday occurring within it, then you count that entire work week as 1 week of FMLA leave, okay? You don't back out the holiday, you count the entire week as a week of FMLA. So that's the easy scenario. The more difficult scenario is what happens when an employee is on intermittent FMLA and a holiday occurs in the middle or at some point during that week. And so the question is, do you get to count that day as an FMLA day? And if so, how much does that count toward the person's leave calculation? Because that makes a big deal in the end. You don't want to shortchange somebody FMLA time, because that's a certain way to end up with a claim. So if the employee is only working a part of a week, but they do work at least a day or some part of it, then you do not count the entire work week, of course, as FMLA, and you would not count the holiday. So if an employee works 3 days a week, and and then the fourth, well, like how many days are there? There are 5 days a week, right? All right, so let's say they work 4 days of the week, and the holiday occurs on the 5th day. Then the issue is, how many of those days are you counting? Obviously, you're only counting the days that they actually work, but how much does it count toward the FMLA? So the DOL has not specifically answered this question in the regulations, but the insinuation and some indications that they've been given is that you would not calculate it based on a 5-day work week. You would calculate it based on a 4-day work week. So when you're computing the percentage of FMLA leave, you are computing it on a 4-day work week, okay? So you're not counting that holiday in there at all. All right, and if that didn't make sense, or if you have questions about anything else, please shoot them to us. We cannot see them as we're going along, at least at this point in the presentation, but we are maintaining them in some fashion, and we're going to come back to them at the end of our sort of lengthy session after the last break. So we will get to your questions, and so feel free to let us know what they are. So the second FMLA issue does have something to do with COVID and this whole idea about remote workers, because that concept does not appear to be going away anytime soon. And the question is, though, how do you administer and how do you count, or how do you even apply the FMLA when now some or all of your workforce is not working in the office? And what I mean by that is, how do you determine whether to count those people at all anymore, and do you have to count them? So, so this is really important, because state and federal say different things about this. Because as you know, there's different requirements for when each of them apply. So state law only applies when you have 15 or more employees in one location in the state, okay? But federal applies when you have 50 or more within a 75-mile radius. So you can have more than one site, and as long as they add up to 50 between those sites and the sites are within 75 miles of each other, then you are covered. So what happens when half your workforce has taken off for Florida or somewhere warm or somewhere outside of Maine to work remotely from their RV? Because you're not counting them in that state, although that raises a whole different issue about whether or not leave laws in the state they're in now apply to them. But for purposes of Maine, you can't just simply discount them by saying, well, they're working out of their RV and therefore they're not at my location and therefore they don't count anymore. What the DOL says, this is federal, not Maine, but I would say you could apply the same law to Maine. Federal says that you're not looking at where they're located when they're remote, or on a job assignment or somewhere else. You're looking at where is their primary work location and where are their assignments coming from. So if you still have an office in Maine and you are administering or sending out assignments or dealing with employees from that office, as long as you still have the requisite number of people, they are still going to be covered by the FMLA. So as an example, so state, remember, is 15 or more at one location in the state. So if you're sitting here in Bangor and you no longer have 15 bodies in your office, because they have gone remote, and before COVID you had 35 employees, and now let's say you have 10 sitting in your office and 25 are in sites unknown around the world, as long as you are still assigning work and they are reporting back to you in your office, all of those other 25 people still count. So you are still going to be covered by the Maine FMLA, okay? And the same is true of federal. So I just want to be sure people don't think that just because employees have physically vacated the premises, that means that you're now free to no longer apply the FMLA. So it doesn't work that way. The other thing about this sort of COVID situation that's raised FMLA issues is whether or not something counts as a serious health condition. So I don't want employers to just jump to an assumption that anybody who's out because of COVID is automatically covered by FMLA and start running that time concurrently. Because even though it's leave, you can't forget that the FMLA requires somebody to have a serious health condition, or they're needed to care for somebody with a serious health condition. In a lot of cases, ordinary symptoms of ordinary COVID don't rise to the level of a serious health condition. They might, but they don't always. So you need to make sure you're making that assessment before you just randomly start the FMLA running. And it's because it's not triggered just by the fact that they're out. It's still you still have to apply the rules. Now, needed to care for is different, because if they are caring for a family member with COVID, then that may very well meet the definition. In fact, it probably does. And so then their FMLA may apply under that category instead. The one thing I will say about this, though, is that we are now seeing what they're calling the long haul cases, right? So these are people who had COVID, and now the symptoms, they appear to morph into something different, and in some cases more severe than the actual COVID. And so those cases might actually turn into serious health conditions. So you need to monitor if people are out and all of a sudden they start reporting, I need to be out longer, or the symptoms have changed, or the situation is more serious. You may need to do a recertification or an initial certification to see if they are now covered by FMLA, because their condition has now become a serious health condition. All right, so don't forget about that. Also, just as an aside, long haul symptoms can certainly also be disabilities under the ADA and the Maine Human Rights Act. And we have seen cases where the ordinary COVID symptoms were not, but once it turned into the long haul, people became much more incapacitated, and it did count. And then the last thing about the COVID stuff is they have reinterpreted the FMLA in terms of what kind of doctor's visits are required for the FMLA to apply. And now they have, they, meaning the DOL, has recognized that remote visits to physicians or healthcare providers of any kind are count under the FMLA. So the employee does not have to be able to visit that doctor or the healthcare provider physically in person. These remote visits now count in terms of the determination of whether or not somebody has a serious health condition. And I don't see that changing anytime soon, because it seems like that system is working well for a lot of people. And in fact, it may even make it easier for you to get the certifications if the doctors can see them faster, because they're remote visits and being done by telemedicine instead. But you do still need the completed certification. So even though the employee is not going to the office in person, they do still need to have that certification completed by the physician or their office. And then the last thing I wanted to raise is don't forget that the EPL is still out there in terms of sort of unrelated leave issues. Random leave issues is what I'm calling them. Because with everything else going on, and I know a lot of you have been amending your handbooks to talk about some of the new legislation, some of the new leave issues. In doing that, do not forget that when you have people out on leave or requesting leave, you have got to apply this EPL. Now, we're almost a year into it being applicable. What I'm finding is that a lot of employers, by no fault of their own, are just simply forgetting that this was out there, and that not only are you needing to track the, I hope all of you know what I'm saying when I say EPL. I'm talking about the earned paid leave law that went into effect last January. It's necessary that you track that time, but also remember to apply it. So if somebody wants to go out because they have a family member and they want to protect them from possible COVID exposure, even though they're not sick themselves, and even though they don't have COVID themselves, or they haven't been advised to quarantine, that may be a very good opportunity for someone to use their EPL. Remember that it is not specific to medical conditions. It covers leave for any reason the employee wants to take leave. And the only difference in the kind of leave, the reason for the leave they're taking, is in the notice that the employee has to give you. So for a emergency situation, it's essentially notice as soon as they can or as soon as practical. For leave for all other reasons, you can ask for a reasonable time, which is sort of a general guideline they've given us, is around 4 weeks is even reasonable to ask for someone to schedule that time off. And so now we're coming to the end of the year. Hopefully your policy has already addressed what happens at the end of the year in terms of turnover of that time or carryover of that time, and you're prepared for that situation. If it doesn't, and if your policy doesn't address this at all, and if you have no idea what I'm talking about, either please let us know so we can help you out with that, or find out, because it's imperative that you apply these. And I think those were all the general leave issues that I wanted to talk about at this point. And we're within a few minutes of our time anyway, so I am going to move on to our next presenter, and you will see his 2 truths and a lie. And that is Josh Ramlet, who's going to talk about wage and hour issues. So thanks, and I'll be back.
Good morning, everybody. So those are my 2 truths and a lie. Drop your guesses in the comments. I'll give everybody a couple minutes. We've got 2. What are the guesses so far?
That's it. The 2. Number 2.
Number 2? Well, I've got to say, I've got a funny story about this. So last week when we were preparing for this, we roundtabled my 2 truths and a lie, and the overwhelming majority of people that we tested this with also picked number 2 as the lie. In fact, number 1 is the lie.
Yeah,
number
all to you.
Number 2 is completely true. And you know, I've got to be honest, I'm not quite sure how to take that. I mean, on the one hand, I could take it as people think that I'm this really cool biker dude. But on the other hand, people don't believe that I'm, you know, in physical shape to run a marathon. So I guess I'll take it with a little bit of both. In any event, 2 is absolutely true, and number 3 was true. I did crash a moped in Bermuda, and that's also why number 1's lied, because after crashing the moped, I don't dare get on a motorcycle. So anyway, I am here to talk about wage and hour issues.
Should be good.
If I can figure out the clicker, we'll make this work.
There you go.
There we go. So we'll start with some state and local issues, and then we'll move on to some federal stuff after that. On the state side, a fairly quiet year. There are some important updates to go over. First and foremost, as you all know by now, the minimum wage here in Maine is now indexed to the Consumer Price Index. So it increases every year on January 1. For next year, that new number is going to be $12.75 an hour. So mark that down. And as you also know, exemption amount for salaried employees is related to the hourly wage as well. So that increases to $735 and change a week, which comes out to just a little over $38,000 a year annualized. So to the extent that you have exempt employees, you're going to want to take another look at that to make sure that they're still satisfying that threshold amount. But also importantly, remember, salary is just one factor for exemption. So, you know, that's something that we see more often than we would like, that people think you can just give somebody a salary and they're exempt from overtime. That's not the case. You have to meet some other factors as well. The tip credit, for those of you in the food service industry who use the tip credit, that's also tied to minimum wage. So that is now going to increase this year as well. That goes to $6.38. For anybody who has a location in Portland, I'm sure you're well aware by now that they have their own minimum wage requirements. That increases in January as well. That's going to go to $13, and that will make the tip credit down there in Portland $6.50. One other thing about Portland that I didn't put on here is that the hazard pay provision of their ordinance that they passed a year or so ago is going to take effect in January of next year, which requires 1.5 times regular rate for workers who are working in a declared state of emergency. But as of right now, we're not in a state of emergency as declared by the governor. But I'm just putting that out there as something that if one is declared, keep an eye on that if you have a location in Portland. A couple of statutes that were passed this year that relate to some extent to wage and hour issues. I'm not going to talk about these in detail because others will be getting into them later on, but one is an act to establish Juneteenth as a paid state holiday. That's June 19th of each year. So I put that out there for any government offices who might be joining us today. In case you follow the state holidays, just keep an eye on that. And then LD 1106, prohibiting employers from charging employees for direct deposits. I believe John's going to talk about that later. Just putting that up there to be mindful for wage and hour issues. Moving on to the federal side, there were some big changes to the tipped employee final rule. This is something that's been flip-flopping back and forth over the past couple of years. Those of you in the food service industry are probably aware of that. We had the 80-20 rule for a fair amount of time. And then in 2018, President Trump's administration basically rescinded the guidance on that. And in 2020, late last year, they actually introduced new rules to officially get rid of the 80-20 rule. Fast forward to 2021, President Biden's administration comes in and they withdrew what the Trump administration had submitted, and they proposed new rules to essentially reinstate the 80-20 rule. So what is the 80-20 rule? It's for employers who take tip credit, and it sets limits on how much time a tipped employee can spend on non-tipping activities. Essentially, what the new rule says is you can only take the credit when the employee is performing tip-producing work or work that directly supports tip-producing work. And they can't spend a, quote, substantial amount of time doing, that should say non-tip supporting work. There's a typo there, my mistake. What is substantial? More than 20% of the hours that they work in a work week, or more than 30 minutes consecutively in one block. So if you're spending that much time doing non-tip supporting work, you can't take the tip credit, and you have to pay minimum wage for time spent in excess of those thresholds. So that begs the question, what's tip producing work? Basically, it's all aspects of the service that you provide to customers for which you receive tips. That's the DOL definition, and that's about as helpful as nothing, because it doesn't really tell you much. But the examples that they give do help to flesh that out a little bit. The examples they give are a bartender talking to a guest, making them feel comfortable, putting it on the TV show that they want to watch while they're sitting at the bar, wiping down their spills, all that stuff that they're providing to the guests who will eventually, hopefully, tip them. Or a server getting a high chair for and a coloring book for guests who have a young child, things like that. That's all tip producing work. Tip supporting work is work set in preparation for tip producing work. Again, not the most helpful definition from the DOL, but here are some examples. Bartender getting a case of drinks from storage out back so that they can stock the bar, or cleaning the beverage station rather than a particular spill for one customer, or a server folding napkins or filling condiment containers, or busser setting tables, things like that. That's all tip supporting work. So you can take the 80-20 rule says you can take the tip credit if they're doing 80% of this stuff. That becomes effective the end of this year, December 28th. So the OSHA ETS, good gravy. If this isn't an example of what has been going on for the last 2 years, I don't know what is. We finally get the long-awaited ETS standards, get ready to put it into a presentation to educate you all on it so that you can be ready when it goes into effect. And what do you know? It's been stayed. So they throw yet another wrench into all this. So as you probably all know by now, OSHA had just recently rolled out these emergency temporary standards for vaccine mandate for private employers with 100+ employees. They rolled them out a couple weeks ago. Just within the last week or so, there have been a number of federal lawsuits filed to challenge that, and the Fifth Circuit Court of Appeals, which is down in Louisiana, entered a stay, an injunction to prohibit enforcement of the ETS, arguably only within the Fifth Circuit. But in response to that, OSHA said that they weren't going to move forward with implementing this standard until they had further guidance from a court. And then since then, a number of other lawsuits were also filed, and they've been consolidated in the Sixth Circuit Court of Appeals on this issue. So as of right now, the brakes have been put on the ETS standards for 100+ employees. So that being the case, I'm going to kind of skip over this for the time being. I'll come back to it if we have time later, or if people want to have specific questions about it later on in one of our other sessions, we can address it, but I won't waste a lot of time on it given its status right now. The U.S. Department of Labor, they issue opinion letters every year, which are helpful guidance for how to handle different wage and hour scenarios. A fairly quiet year at the federal DOL in terms of opinion letters this year. I want to say there were roughly 9 issued throughout the entire year. And they actually withdrew several of them, 3 or 4 maybe. In contrast to last year, there was 21, 22, something like that. So a fairly quiet year from the feds. Here are a few that I thought were interesting. One is opinion letter 2020-19, actually came out last year, but after our last meeting. It deals with the compensability of travel time for an employee who works remotely, but only for part of the day. And here's the hypothetical that they threw out. The employee normally works in an office from 8 to 4:30, and they have a 1-hour standard commute. In scenario 1, they say, assume that this person leaves work at 1 o'clock in the afternoon for a parent-teacher conference at their child's school. They drive 30 minutes from work to the school, have their meeting, and then they drive 30 minutes from the school back to their house. And then they work out the remainder of their workday at home remotely. And the question is the time that they spend driving from their office to the school compensable? And how about the school to the house? So that's fact pattern number one. Number two, I'm going to get to the answer later because it's the same for both questions. Hypothetical number two, the employee starts working home early at 6 o'clock before their normal shift would start. Then they leave for a doctor's appointment at 8 o'clock. They drive 45 minutes to their doctor's office. They get there, they have their visit, and then they drive 15 minutes from the doctor's office to their work office. And they work out the remainder of their day at the office like they normally would. The question there is the time they spent driving from their house to the doctor's office compensable? And how about the doctor's office to their work? And how about their office to their home at the end of the day? The DOL said in each of these scenarios, the answer is no, none of this time is compensable. They said it is not worksite to worksite travel because none of this travel is related to the employee's work duties. It's personal travel for personal reasons. And it's not part of a continuous work day because during these times that the employee is driving, she is completely relieved from all work-related duties, and she's able to use that time for her own purposes for whatever she wants to do. So none of that time would be compensable in those scenarios. Opinion letter 2020-18 came out late last year as well. This addresses the question of what's agriculture for exemptions. This one I just picked because I thought it was a really interesting fact pattern, but it could potentially be relevant to some of the employers we have here in the state because we have lots of different types of agriculture. The farm at issue here is one that I'd never heard of before. It's an insect farm, and they make, quote, superworms, end quote, for animal feed. And they also raised crickets and some sort of roaches, I'm not even going to try that, for human consumption. And they had 3 different types of workers at this farm. They were all paid hourly. They had workers who fed, watered, harvested, cleaned, and breeds the insects. Not a job that I would want. The second category of workers are the managers who oversee everything. And then the third category is facility workers who do maintenance for where the animals are kept and so on and so forth. The question is, are any of these people employed in agriculture for purposes of fitting in under one of the exemptions for agriculture? The DOL said that agriculture includes traditional farming in all of its branches, which includes the raising of livestock, bees, fur-bearing animals, or poultry. This case actually ended up going to the Sixth Circuit, or a related case that was the impetus for this letter, excuse me. And the Sixth Circuit said that, yeah, that's all true about what they delineated for agriculture in the DOL regs, but Congress actually meant agriculture to be really, really broad. And they said, if you really think about it, there's not much to distinguish worm farm from traditional farms, other than the fact that it's a wacky thing that you don't see any day. And the meaning of farming isn't frozen in time. So I thought that was interesting because if you, you know, we have companies around here that raise animals to be feed for other animals or raise animals for non-traditional purposes. If that's you and you haven't already looked at this, you might want to look at this to see if you could fall within agriculture for an exemption. Opinion letter 2020-1, this is the first one from this year. The question is, what falls within the scope of the administrative employee exemption? The facts were that the company is a life sciences products manufacturer, and the employees are account managers. They have at least a bachelor's degree, and they consult regularly with scientists who are their ultimate clientele. They learn about the client's needs. They research what sort of products their company has that might fit those needs, and they work with the client to develop individualized plans to figure out, hey, I think these products would work best for you, and here's how we can package them. They're paid a base salary above the minimum threshold, and they also get commissions. The question is, do these people qualify as exempt under the administrative exemption? The DOL said yes. As just a refresher, they said that the administrative exemption applies when you're paid, number 1, on a salary or fee basis. Number 2, your primary duty is office or non-manual work directly related to the management or general business operations of your company or your customer's company. And your primary duties also include the exercise of discretion and judgment with respect to matters of significance. And so the DOL looked at all this and they said that the account managers here, they're non-manual work and it's directly related to the management and operations of their clientele. And they're engaging in significant work that's not just merely closing sales. It's not like somebody comes to them with a pre-filled out sales order that they just sign off on. But instead what they're doing is they're working very closely to tailor-make something for this particular customer's needs. And then if I can get the next slide to come up. All right, so that's why that was the most particular or the most significant fact that the DOL ruled on for the administrative exemption was the fact that this was a custom-made plan for the customer. Letter 2021-6 is a staffing firm, a retail or service establishment. Again, this comes for potential exemption issues. It's a staffing firm that places workers in temp to hire positions. They sign a worker to work with a client, and they employ that worker for a period of time, and they're the one who pays their wages and benefits and insurance. And then if after a period of time the client and the worker agree to enter into a permanent working relationship, the staffing firm and the temp worker part ways at that point in time. The question in that one is, are the employees of the staffing firm who are engaged in operating the business, so the people who are actually sending the clients or the workers out to different clients, are they eligible for the retail or service exemption? So not the temp workers themselves, but the other people. The DOL said maybe they are. They said there's an exemption for employees who work at a retail or service establishment whose regular rate of pay exceeds 1.5 times the minimum wage and whose earnings in a representative period are more than 50% commissions. And so they define, what's interesting about this one is they define what's a retail or service establishment. And it's a business that's engaged in making the sale of goods or services, and 75% of those have to be to retail, and the flip is that is not more than 25% for resale. The DOL said that the sale of staffing is a sale of goods or services. And for the retail prong, they said what you look to is, are you making this available to the general public? So, general employers. Is it something that serves the everyday needs of the community? Is it the end of the stream of distribution, meaning you're not loaning out workers to another temp agency, but you're right to the end client who's going to need their labor? They say if you tick all those boxes, then that can be sale of goods or services in retail, and therefore your employees might be able to meet this exemption. So if you're a staff agency and you haven't looked at this one, you might want to take a peek at it. And then just to quickly wrap up, you all might have heard of the PAID program, which was something that was implemented by the Biden administration. It's the Payroll Audit Independent Determination Program, which was a federal program that allowed employers to self-report essentially minimum wage and overtime violations to the federal government. And the way that it worked is if you had violated the laws, you would pay the wages that were owed, but you could avoid penalties and liquidated damages. That program has been terminated by the Biden administration, ended January of this year. It's probably signaling that the Biden administration is going to take more of an emphasis on DOL-initiated audits, presumably with a bigger focus on liquidated damages and penalties for violations. So the program is done. Don't go self-report anymore if you have any wage and hour violations. It's not going to work out well for you, and just keep this one on your radar. And with that, I will introduce our next speaker, who will be John Hamer.
All right, thank you, Josh. Let us see. Oh, now I can see the screen. That's good. All right, so these are my truths and a lie, and I will not tell you which one is true. No, I will. So I was going to have up there, my wife was once chased up a mountain by a monkey, but that was already taken. So that turns out to be true. My false is number 2. I've not hiked the John Mayer Trail in California. It sounds like a fun hike. I do have an IMDb profile on the internet for Survivor Pennsylvania. Someone in production put that up for me. I don't know how to access it. I don't know what it means, but it's there. If you search for it, it's a very sad looking entry, but it's there. And the other one is I have appeared in Rocky Horror Live. That was this October. If you know the show, I was the narrator. I was the guy who says, it's just a jump to the left. And so that was my claim to fame there. And as an aside, that was with the Sun Theater Company, which is located in the Bangor Mall. And they've got the Brothers Grimm Spectaculathon running from December 9 to 12. Get your tickets. So, all right. Anyway, let's see. I'm here to talk to you about something equally interesting, what's new at the Labor Relations Board. So you probably remember, 10 or 12 years ago, we tell you about all these new cases and new decisions that were very restrictive on social media and all these other types of issues. And then more recently, we've said, the MLRB has moved away from that. You can forget about those old rules, and this is the new rule. Well, it looks like we're going to be heading back to the old rules in quite a few subject areas. And we don't know exactly where this is going to land, but it looks like we're going to see some of the more recent cases being overturned and having the old standards reinserted. So, and this is, of course, because the Biden administration, they're having their impact in the labor relations realm. The first thing that, well, not the first thing that President Biden did, but one of the first things that he did was to fire General Counsel Peter Robb, and that happened on Inauguration Day. So he was pretty serious about that. Since then, he has named Lauren McFerrin as the chair, replacing a Trump appointment, John Ring, who is still a member of the board. He had been the chair. His term ends up, it winds down in December of 2022. We're 2021 now. And then there's one other Trump appointee on the board, and that person remains until 2025. President Biden had appointed 2 Democratic members on July 28th of this year. And so now there's a Democratic controlled MLRB, and it's going to be even more so when Member Kaplan's term, Member Ring's term ends at the end of December of 2022. So shortly after that, President Biden appointed a new general counsel. And the general counsel is the person who tends to, well, they don't run the board, but they do have an agenda, and they do try to push the issues that they think that are important, that the board thinks are important. So the new counsel is General Jennifer Abruzzo. She was appointed in mid-August. And one of her first acts was to issue a memorandum called the Mandatory Submissions to Advice. And now a copy of this is located on our website. All of the documents related to this seminar are available on our website. Feel free to visit rudmanwinchell.com and you can find all those documents. But this mandatory submission to advice is basically her roadmap. It's been called her roadmap to her political agenda in terms of the areas that she wants to see board address. And I'm going to go through some of the different areas that we're likely to see changes in. And these are major changes because during the last term from 2016 to 2020, we saw quite a few longstanding board precedents overturned, and we're going to see those re-examined and perhaps even expanded upon. So these, let's see, these are the areas to watch out for. The first is employer handbook rules. Now, we can pretty much expect more restrictive employee handbook rules to be taken to take effect in the next couple of years. Back in 2017, the board had decided Boeing Company, which allowed for a balancing of the employer's business justification with its effect on employee rights. We're likely going to return to the Lutheran Heritage Standard, which basically said that where there are facially neutral policies, they'll still be held unlawful if an employee could reasonably read to prohibit or limit their exercise of Section 7 rights. As you may recall, Section 7 of the NLRA guarantees employees the right to self-organization, to form, join unions, to bargain collectively, and engage in concerted activities for the purposes of collective bargaining or mutual aid and protection. And it's illegal to interfere with these Section 7 rights. And these Section 7 rights apply to not only unionized shops, but to any private employer who is subject to the NLRA. And they have a pretty broad jurisdiction. So that's a pretty important area that we're going to have to perhaps take a look at your personal policies again to make sure that whatever rules are reestablished are being applied. Take a look at your personal. All right. That includes confidentiality provisions and separation agreements. There's going to be more restrictions on those. The board's going to likely take the position that confidentiality is going to prohibit employees from learning about terms and conditions and what other employees have managed to get for agreements with the employer. The next area that we're likely to see change in is the General Counsel's burden for showing violations. The longstanding right line test basically requires the GC to show that discipline or adverse job action was taken because the employer engaged in Section 7 rights. The employer would have the right to show that it would have taken those same steps anyway. The GC wants to now require make it easier for an employee to show anti-union animus and pretext. We're not sure exactly how that's going to land out, but that's likely to be a focus of some of the new cases. Union access to employees, that's going to be a big issue in the next 4 years, the next 3 years. And one of the major areas is going to be a battle over employer email systems. We recently, in the past 5 or 6 years, got away from the corporate communications rule that said employees have the right to use an employer-controlled email system. That went away, and we're likely to see that reinstated, perhaps. Employee status. The GC is looking at going back to the more liberal definition of, or actually restriction on who can be a general contractor for purposes of the NLRA. Because if you're a general contractor, then you're going to be not covered because you're not an employee. So they're going to tighten up the requirements for who's a general contractor under the NLRA jurisdiction now. That won't change in terms of our local standard, but if you've got a private company covered by the NLRA, you could see changes, and you could see 2 different standards applied, one for employment purposes or for general contractor reasons for different, well, I'll forget about that. Anyway, we're going to see a more restrictive definition likely to come forth. Jurisdiction over other institutions. The GC is seeking to expand jurisdiction over religious institutions and student organizations. We've had some recent cases that have exempted those, especially students, and the board is interested in taking over those areas again. Employer duty to recognize and or bargain. This is the requirement that when your employees come to you and say they want to meet and discuss some terms and conditions of employment, that you have a requirement to meet with them and to bargain. Now, the difficult thing with this is that even where your management rights clause or even the contract itself expressly gives you permission to engage in an act or an action, the employees can still demand impact bargaining. So that's likely to be expanded upon. And impact bargaining is saying, yes, the employees are saying, yes, we know you have the right to make this change, but there are impacts from this change, and that will impact a mandatory subject of bargaining, and therefore we would like you to meet us and discuss those impacts to see if they can be mitigated. All right, I've got a couple more to go through. Weingarten rights. Weingarten rights refers to the right of a union employee to be represented during an investigatory interview that could result in discipline. This happens in a union context. A while ago, probably actually it was prior to 2004, that was the case for everybody. It doesn't matter if you were in the union context or not. If you have an employee in an investigation that could lead to discipline, they would have a right to bring a coworker into that investigation. In 2004, there was a decision that said that Weingarten rights did not apply in non-union settings, but the General Counsel and the board are heading back to the old standard, so that may be reinstituted. And then let's see, the final section I'll talk about here is Josh recently mentioned the EATS, or the ETS as they probably should be pronounced, OSHA's new regulations, and while they may be stayed, the NLRA-B has put out some of their own thoughts on the matter. The GC takes the position that certain aspects of the ETS affect the terms and conditions of employment. Therefore, there's an obligation to bargain, and so whatever is implemented, whether it's mandatory, whether the employer has discretion in how to implement, that's going to impact employees, and therefore they have the right to either bargain or impact bargain implementation, should it ever happen. It will happen in some form at some point, I'm sure. All right, so expect big changes. Hopefully we'll have some more hard and fast rules for you next year, but right now we just have these lot of issues and areas to keep an eye on in the meantime. All right, so our final speaker in the rapid fire session is going to be Brent Singer. And
hello, I am Brent Singer. Welcome to our 19th annual seminar. And I'll give just a moment in case anybody wants to take a number 3 is what people think is a lie. Oh, come on. Oh, number 2. Well, all right. Well, I did once live in a milk truck for 8 months. And I'd wake up and my boots would be frozen to the floor, which was sort of fun. And I am growing a ponytail because it's my last chance, and you can't really see much of it yet, but it's getting there a little bit. We'll see what happens. Maybe next year at our 20th anniversary seminar, we'll have some real action going there. I am going to make a public announcement about my ponytail, which I've not yet made. I also plan on dyeing it, if I can, to accentuate it. It's a holdover from the 60s, I know. And I never bicycled because I honestly hate bicycles. To ride one, I don't mind if you ride one. I mean, you know, but I hate bicycles. To ride one. So, restrictive employment covenants and contractual issues. And let's see, the biggest challenge, of course, for me is to see if I can get this to work. Anyway, Maine does have a statute about non-compete agreements. We went over that last year, so that's why I call it a refresher course. You simply cannot, well, I'm going to go out of order just a tad here because the next slide, I believe, is what is a non-compete agreement. And the traditional non-compete agreement was, as it sounded, you'll say the former employee is prohibited from competing directly or indirectly in any way against the former employer for some amount of time. And it was just couched in terms of you can't compete. And sometimes they would be couched in terms of you can't do it within 50 miles of the employer's location, back when location had more, mattered more, and it still matters in some industries and businesses. Sometimes it just said you can't work for a year as an optician, for example. Usually it said you can't work as an optician or something or other within 50 miles of the employer's former location or some amount. Those are definitely non-competes covered by the agreement. Probably, and I'm beginning to think almost certainly, the old-fashioned just, you can't compete directly or indirectly against the former employer for a certain amount of time. Those are non-competes within the meaning of the agreement statute. What's not a non-compete, and so where the trend is really moving now is towards so-called non-solicitation agreements. And that's where the employer identifies specific accounts or customers and says, after the employee leaves for any reason, the employee cannot, for a certain number of years, solicit and take business from any of these particular customers or clients. And often there's a list, even depends again on the business and the industry, whether it's you can have a list or not, whether that's practical. And often they prohibit solicitation of prospective clients or customers defined as customers that the employer is trying to get business from within a year before the employee leaves employment, for example. And also restrictions on the use of confidential proprietary information are also not non-competes within the meaning of the new statute. So if you do have a non-compete though, and as I say, we're seeing less of those, the statute says, well, if it is a non-compete, you can't do it if the employee makes less than $51,520 a year. That's for 2021. It'll go up slightly for 2022. Furthermore, if the employee signs the non-compete, regardless, it can't take effect until the later 6 months or 1 year. And the 6 months means 6 months after the signing of the agreement, or 1 year of the employee having worked for the employer, whichever is longer. So if it's a new employee and you want me to sign a non-compete, then even if it's otherwise lawful, it's not enforceable for 1 year. So he could quit right before the end of the year and violate the non-compete, and you couldn't do anything about it. You also have to disclose the requirement before a job offer. If there's going to be a non-compete, you have to give the person at least 3 business days to consider it. I put asterisks by those 3 because for each of those, if you violate it, it's a penalty of not less than $5,000. So that's rather a lot. And I do find that probably still people forget the requirement to disclose that there's going to have to be a non-compete before the job offer because a lot of times employers just forget about it or they don't like saying that, but it's part of the law. But again, this is only if it's a non-compete. If it's a non-solicitation or a confidentiality provision, it doesn't fall within the statute. Obstacles to enforcement of non-competes, even if, and this would be to some extent even non-solicitation agreements, can be reputation in the community, although that cuts both ways. Some employers would want to show that they are tough on enforcing these sorts of things, and so they're quite happy to have that reputation in the community. In other situations, the employer could lose goodwill by attempting to enforce it because some possible employees who might otherwise go to work for that employer might be put off by that, and by word of mouth say, well, I don't want to work for them because look how badly they treat their former employees. Costs money to enforce these things. The facts sometimes are difficult to prove. If you win, it can be tough to collect. There are interstate complications if the employee goes to live somewhere else and is competing there. And regardless of whether or not it's a non-compete within the meaning of the statute, the law is still that judges will not enforce it if the judge deems it, quote, unreasonable in duration or territory. It's, you know, it's difficult for me to imagine a case where if it's purely a non-solicitation agreement, where there's a list of customers that are off limits to the former employee, I don't see how a judge could say that, well, that's unreasonable, if frankly, for any duration, but maybe if you said 50 years or something, might be deemed unreasonable. But nevertheless, lawyers can be pretty clever about coming up with various arguments, and some judges are unpredictable, and what is reasonable and what is not reasonable. So you never really know when you get in litigation, and so it is another potential obstacle. A different statute, which went into effect on September 19th, 2019, pertains to so-called restrictive agreements, and it's an agreement between employers that restricts one employer from hiring the other's employees or former employees. And that's simply unenforceable in Maine now, even if that agreement was entered into before September 19th, 2019. And there have been a couple of cases that have acknowledged the validity, I'll say, of this statute, even with respect to contract entered into before September 19th, 2019. And so it's simply unenforceable. It's a little bit, it sounds simple on its face, agreement between employers that restricts one from hiring the other's employees or former employees. It's sometimes not totally clear what it means by employer, though, in certain situations, because you'll see in some business deals, I'm the sole owner of a company, and my company employs people. I don't employ them, at least certainly not directly. My company employs them. I'm selling my company. Someone else buys the assets of my company. And one of the things they want is for me to promise that I'm not going to solicit some of my former, some of the employees of the company that I used to own to come work for me in some other capacity. And so if I sign that, am I an employer or not? And I suppose if I do sell my company and then I do try to hire one of the former employees of what used to be my company, and somebody says, well, you can't do that, that's unenforceable. I'm probably, when I'm trying to hire that other employee, the employee of my former company, I'm probably doing that in the capacity as an employer. So to make a long story short, as a lawyer, without any court guidance on this, I'm a little bit uncomfortable even having the owner of a company promise not to hire any of the former employees of his company. Merely entering into such a restrictive employment agreement after September 19th, 2019 is unlawful. Just entering into it, and that exposes each employer who entered into it to a fine of not less than $5,000, enforceable by the Maine DOL. And enforcing or threatening to enforce such a restrictive employment agreement is also unlawful. So if there was if back in 2013, an employer signed such an agreement, and it's just sort of been sitting there on the shelf, but now that one of the signatories to the agreement is trying to hire away a former employee of the other one, the aggrieved party could let Maine DOL know, and Maine DOL could intervene, and the employer could be looking at a fine of not less than $5,000. The other statute that I want to talk about briefly here is give a little bit of a historical context. This won't come as a surprise to any of you, I don't think, but it did surprise me a little bit. Right in the statute that was enacted this past year, it recites some of this history. And it recites that since 1965, Maine has had a statute that has provided that an employer may not discriminate between employees on the basis of sex by paying wages to any employee in any occupation at a rate less than the rate at which the employer pays an employee of the opposite sex for comparable work on jobs that have comparable requirements, yada. And in fact, I went back and I looked. In 1965, there was such a statute, and that is exactly the wording from the 1965 statute. It looks like there was a form of the statute that even predated 1965, but it's certainly been on the books in Maine since 1965. So the new statute that was just enacted, which is 54 years and probably more than 2 generations after 1965, says that the legislature has found, and this is this last year, that, quote, despite requirements regarding equal pay having been part of the laws of Maine since 1965, wage inequality is an ongoing issue in Maine. And so the legislature further found that an employer's knowledge of a prospective employee's compensation history is directly related to the practice of basing compensation decisions on compensation history. And when employers do that, that perpetuates the wage inequality. So under the new statute, the rule is, the title of the statute is Compensation History Inquiry Prohibited. And the new statute provides that until an employer has made a firm offer of employment that includes all terms of compensation, the employer, quote, may not use or inquire, so the 2 key words there are use or inquire, about the compensation history of a prospective employee from the prospective employer or current or former employer of the prospective employee. So if I'm thinking about hiring an employee, I may not inquire about, and I may not use the compensation history of that prospective employee. I may not use it at all. Under the statute, it says I'm only prohibited from inquiring about it from the employee or from the employee's current or former employer. But I wouldn't bet too much on whether I might run afoul of this statute if I somehow went to some third party and inquired about it. And the mere fact that I'm inquiring about it presumes I want to use it for some reason, and that would definitely violate the statute. There are some issues about how would one prove a violation of the statute, which you can that going backwards here. There's quite a bit of under the statute, if an aggrieved employee who sues and wins is entitled to the attorney's fees, so that's an important point because that makes it more likely we'll see these cases. Any unpaid wages as sort of a penalty, twice the unpaid wages, and also a forfeiture of not less than 100 nor more than 500 for each violation. I'm going to finish my presentation here by a potential nightmare scenario, because I do some transactional work, and it's not at all uncommon for there to be an asset deal where the seller is selling the assets of the business, and say there are 500 employees. And traditionally, the buyer has always required the seller to provide it a list of all the employees of the seller, including exactly what they're paid. And in fact, the buyer even makes the seller promise it's an accurate list. So suppose the buyer then buys the assets and hires 425 of the 500 employees and starts them at the same compensation as their former employer. And this has happened traditionally for years and years and years. That could well be 500 violations of the statute, which could be up to a $250,000 fine because the employer inquired as to their wages. And then you could have potentially 425 plaintiffs suing for unpaid wages, compensatory damages, interest, and attorney's fees. So the better practice today for buyers is to just get bulk information from sellers about overall payroll costs, or if not, make sure the buyer can prove that the person doing the hiring never saw the seller's list of employees with their compensation histories. Thank you, and we will be taking our first break.
No, because I honestly, I tried to get cool music and I couldn't license it.
everybody, welcome back. I'm sure that you enjoyed that lovely music as much as we did here in this room. Just one housekeeping thing. I am told, well, no, two, I lied. First is I really want to thank those of you who are appearing on the screen. It was at my request, so again, I didn't have to stare at a huge picture of myself. And it's very nice to be actually talking to faces as opposed to nothing. So we very much appreciate your being there and watching. And then I'm told that one of our attendees, Erica Wolf, won this handy dandy, it turns out to be a wine tumbler. So good job, Erica. And so now this next session is about legislative and case updates, and Josh Ramlet is going to kick that off for us.
I know you're all disappointed that I didn't ride my Harley up to the podium. Got to admit, I'm still a little salty that nobody believes I could run a marathon, but we'll move past that. So I'm here to talk about what's been going on at the Maine Human Rights Commission and litigation updates for 2021. We'll start with the Human Rights Commission, and I will say at the outset that there were some tweaks to the Human Rights Act that came down the pike this year. I'm not going to touch those here because Anne Marie is going to be talking about those later on. So this is just kind of what's been going through the Human Rights Commission over the past year. Their annual report came out this past February. I just always think that this data is really interesting. Their total complaints for fiscal year of 2020 is up 8%. They had 775. In terms of their case types, employment, you're still keeping us all busy. It's leading the way at 69% of their cases, followed by housing at 15% and public accommodations at 14%. In terms of the employment cases, disability discrimination is the most common allegation at just under 49%, followed by retaliation of Human Rights Act at 39% and whistleblower at 31%, and it goes down from there. Now, of course, those numbers add up to more than 100%, and as you can probably guess, the reason for that is because in many cases, if not most cases, there's more than one grounds alleged. But I just find that interesting. So make sure you're really thinking through the interactive process and make sure you're very cognizant about potential retaliation claims, because that's where the bulk of these cases are coming from. In terms of how they've been processing cases, about 34% of their cases last year went through complete investigations with reports from the investigators. Roughly 65% of cases are being resolved before the full commission hearing. That's resulted in 196 settlements, 132 right to sue letters, 108 administrative dismissals, and only 23 withdrawals without any benefits being paid to the claimant. Overall, at the entire commission level, they resolved 238 cases. And this is where what I find really interesting about their reasonable ground rates. In cases when there was an investigator report, they found reasonable grounds in about 17%, give or take a little bit. That's up just very slightly from last year. When the investigator's report is contested, the reasonable ground rate is 26%. The overall reasonable ground rate for all filings, regardless of where it resolves in the process, is 6%, and the overall no reasonable grounds rate is 28%. In terms of hearings before the commission, they had 117 that were contested and 121 that went on the consent agenda. And they're very, very busy this year. As you all know, things have been backlogged a little bit. They have 742 cases pending at the end of their fiscal year, which is a 10% increase from the year prior. Their overall value of settlements for last year was a little over $4.1 million. That's a 42% increase from the year prior. I don't think that that means that much additional money was actually paid out in settlements. My experience has been in the last year or so, the commission has been more adamant about wanting to know the dollar value of settlements before they will process withdrawal requests, particularly in cases that are dual filed with the EEOC, because the EEOC has been requiring that. So I suspect that this big increase is a function of more people are actually divulging that information to the commission. Their mediation program has a 44% success rate, and they conciliated 15 cases after a commission hearing with $61,000 and change in monetary benefits to the claimant. In terms of litigation, they filed 7 new complaints, 1 amicus brief, and they currently have 3 cases pending. In terms of case law updates, we'll start with the one that was probably the biggest talk in the state of Maine recently anyway, Doe versus Mills et al. This is the one that just went to the First Circuit recently, and this was the challenge to the healthcare vaccine mandate by Governor Mills that was filed by Liberty Counsel on behalf of a number of healthcare workers. And as you all have seen in the news, the lawsuit was trying to enjoin the COVID vaccine mandate, or more precisely to require consideration of religious accommodations for that mandate. The facts of the case are this. Maine has for many years had a law that requires healthcare workers to be vaccinated against a list of diseases. And historically, there had been 3 categories of exemptions. One was for medical reasons, one was for religious beliefs, and one was for philosophical beliefs. Vaccination rates had been declining for years. So in 2019, the Maine legislature actually eliminated the religious and philosophical exemptions. Then it went on to a people's veto, a referendum, and that was voted on, and 75% of voters in the state of Maine were actually in favor of eliminating the philosophical and religious exemptions. The change to that law technically took effect 2020. 2021, April of this year, the Maine CDC updates its regulations to reflect the 2020 changes. And then in August of this year, the Maine Department of Human Health and Services and CDC, excuse the typo there, issued an emergency rule to add COVID-19 to the list of diseases that require mandatory vaccinations, unless there's a medical exemption. The plaintiffs in the Doe case claim that they have sincerely held religious beliefs against taking the COVID vaccines due to the use of fetal cells in either the research or production of the vaccine, depending on which vaccine you're talking about. Their argument in the case was that this mandate is preempted by federal law, the First Amendment, equal protection, supremacy clauses, so on and so forth, and that it also violates Title VII. The First Circuit said that the plaintiff's First Amendment rights were not violated here in this case, the free exercise clause. And the analysis I thought was very interesting. A law that's neutral with respect to religion and generally applicable, that incidentally burdens the free exercise rights of your religion, will be upheld if it's rationally related to a legitimate government interest. A law that's not neutral with respect to religion or is not generally applicable has a higher standard that it needs to meet, and it will be upheld if it's narrowly tailored to achieve a compelling governmental interest. So one of the battlegrounds in this case is, well, which standard does this law fall under? Is it a rational basis test, or is it a narrow tailoring test? The First Circuit decided that this law passed either standard. In terms of a rational basis, they said that the law was neutral. It doesn't single out any particular religion or religious practices. And as evidence of the fact that it wasn't just targeting religion, they pointed to the fact that the philosophical exemption was also removed. The First Circuit also said that it's a law of general application. It didn't just burden religious conduct while exempting comparable secular conduct, and comparable is important because they said that a medical exemption is not really comparable to a religious exemption because the whole purpose behind the law is advancing public health, and making somebody take the vaccine if it's medically contraindicated for them does nothing to advance that public health purpose. Then they said, in any event, even if it were subject to strict scrutiny, it would still pass under that standard because stemming the spread of COVID is unquestionably a compelling government interest, and this law is narrowly tailored. And evidence of that was all of the other tools that the state has had available and that healthcare agencies have had available to try to combat COVID, masking, voluntary vaccination, PPE testing, so on and so forth. That hasn't been completely effective or as effective as it needs to be. And evidence of that is multiple outbreaks that have happened in healthcare facilities. So then the First Circuit said it doesn't violate the First Amendment rights, equal protection, that kind of goes away once the free exercise challenge fails. The Supremacy Clause, which says that federal law trumps state law, that was a straw man argument. Basically, the plaintiffs there were trying to make the argument that the state of Maine and the healthcare agencies that were named as defendants were claiming that the protections of Title VII don't apply in the state of Maine, and the First Circuit didn't give that much credence, nor should they have, because nobody was actually making that argument. The question was whether or not, well, we'll skip that. Anyway, moving on to Title VII, the Title VII analysis. This was at the preliminary injunction phase. So in order for the plaintiffs to succeed on getting the law enjoined on those grounds, they had to prove a number of things, one of which was likelihood of success on the merits, which for the reasons we discussed, the First Circuit wasn't sure they could do that. But beyond that, they have to prove irreparable harm, which is some form of harm that can't be appropriately remedied through money damages. And the First Circuit said that typically loss of employment or employment-related claims don't have irreparable harm. We get these cases all the time where people lose jobs, and their remedy is to get back pay, front pay, compensatory damages, all that sort of thing. So there might be a case where there's irreparable harm, but they haven't shown it in this one, is what the First Circuit said. In terms of next steps, the plaintiffs in that case moved for injunctive relief pending cert before the U.S. Supreme Court. That was denied by Justice Breyer, with Justices Barrett and Kavanaugh agreeing with him. And there was a serious dissent from Justices Gorsuch, Thomas, and Alito. So it remains to be seen what's going to happen here. But if I had to guess, I'm thinking that this isn't the last we're going to see in this case. A couple other cases to quickly touch on. Gonzalez Bermudez versus Abbott Labs out of the First Circuit. This was an age discrimination claim and a retaliation claim based on a demotion. I've just been told that I'm long-winded here. I'm running out of time, so I'm going to move through this quickly. But the interesting thing on this one is that it talks to what you need for comparator evidence. They need to be similarly situated in all material respects. In other words, you have to be able to compare apples to apples when you're trying to prove discrimination by saying, look, this is what happened to other people or what didn't happen to other people, and I was treated differently. In this case, the two comparators had different jobs. They had different job duties. They had different supervisors. There was no evidence if they had any issues with their job performance. So the First Circuit said, we don't know enough about these people, and they're not similar enough to the plaintiff that we can't use them as comparators. And with that piece of the case gone, there's no evidence of age discrimination. The retaliation claim was based on a failure to promote after the plaintiff had complained about age discrimination. Basically, what happened here was she applied for a promotion. Everybody who applied had to do, and who was going to interview, had to do a mock interview or a mock presentation, excuse me. The employee refused to participate in that because she thought it was basically a done deal. They'd never take her seriously. And the First Circuit said it's not for the plaintiff to predict the employer's hiring decision and then claim to be the victim of that predicted decision. So by the fact that she didn't participate in part of the application process, she basically took herself out of the running to be a qualified applicant, and therefore she loses on that. Netto versus Twin Rivers Paper, this is a Maine case. This is a whistleblower case. I won't harp on this one because I have another one I need to get to. But the interesting thing about this one is the interplay between the Federal Labor Management Relations Act and the Maine whistleblower law. And the takeaway from this case is if you are unionized and if an employee makes a whistleblower type claim, if the case requires you to dig into the CBA to figure out, what's permitted under the CBA or what rights the employee has under the CBA, if you need to dig into that analysis to evaluate the whistleblower claim, the case is actually going to be preempted by federal law, and that needs to go through federal court, not state court. So that's what's interesting about this case. Two quick cases that I do want to touch on: Woodland Senior Living and Osmond Page. These both address Title 26, 599B, which Brent talked about earlier, which is the Restrictive Employment Covenant, Restrictive Employment Agreement, excuse me. Basically, this both cases dealt with very similar issues with respect to those agreements. Number one, do these agreements apply in the context of a staffing agency? And number two, does it apply even if you entered into these agreements before the law took effect? In other words, by saying that we can't prospectively enforce a contract that we entered into previously, are you depriving us of our contractual rights? Is there a due process issue? In both cases, sorry to say, the law did not come out good for employers who want to enforce these agreements. Both judges in these cases said that 599B does apply to staffing agency and temp agency type arrangements. There's nothing in the law to suggest it doesn't apply to them. So for our staffing agencies or our temp agencies, I know that these are very common agreements that, you know, basically I'm going to place my employees with you and you can't steal them from me and I won't steal yours. Unfortunately, 599B, at least as of right now, the case law is indicating it would prohibit that. So I guess the answer to that point is to get active in the legislature, use lobbying efforts, and get that law changed. Both judges also said that there's no retroactivity problem with prohibiting enforcement prospectively, even though these contracts were lawful when they were entered into. They said that there's no constitutional issue because the state has a very important interest in attempting to make it easier for people to work and not be restricted in where they're working. And these laws are narrowly or reasonably tailored to accomplish that goal. And it was just a reasonable basis test that the court used in both instances. And unfortunately, the end result of that is no constitutional contracts claim issue there. So even if you had these, they were lawful when you signed them, you can't enforce them going forward unless and until the law is changed or some other judge disagrees, but I don't think that's likely to happen. So that's the case law update. Speaking next about some legislative updates will be Brent.
Thank you, Josh. Get all my tools here. Trying to figure out what glasses to wear. That's always a trick as well. I'm going to just be talking about a few recent new legislative, new pieces of legislation. The first is LD 137. The official title is, an act regarding absence from work for emergency response. You have, I'm told, at a click away or something, copies of these newly enacted laws. This one was really just a technical correction to an existing law, technical clarification, but it's an existing law that perhaps not all employers are familiar with, or lawyers for that matter. And so it might behoove us to sort of go over it a little bit. It applies, this particular leave law applies to all private and public employers, and it covers firefighters, both municipal and volunteer, and emergency medical service providers, which are defined in the statute. And they are pretty much what you would expect they are. They're people who routinely, as part of their job, provide emergency medical services either at the scene of the patient's illness or injury or during transportation to a hospital. The statute prohibits the employer from taking adverse employment action against the firefighter or emergency medical services person who is late or absent from work because they're responding to an emergency in their capacity as a firefighter or an emergency medical services person. the employer may charge lost time against regular pay or available leave time. I was struck when reading this statute that it's not particularly friendly to firefighters or emergency medical services providers, but it at least does prevent employers from taking adverse action against them. It requires the employee to make every effort to get back to work as soon as reasonably possible after being released from the emergency. But it has very limited remedies for the employee. The employee may sue the employer within 1 year after the employee believes his or her rights were violated. And the employee is entitled to back pay, reinstatement, or other relief that would put the employee in as good a position had the employer not violated the statute. But the statute doesn't provide for attorney's fees, so that makes it difficult really for an aggrieved employee to bring an action. And then there's a bunch of ways in which the statute doesn't apply at all. It doesn't apply to employees designated as essential in a writing signed by the employer and the employee, where essential means the absence of the employee would cause significant disruption to the employer's business. The statute doesn't apply to police, utility workers, or medical personnel in the course of their regular employment as such, which that makes sense. The statute doesn't apply if the employee and the employer already have some written understanding between them that governs, quote, procedures to be followed when the employee is called to respond to an emergency. And then last but not least, the statute doesn't apply at all unless the chief of the fire department, with respect to firefighters, or the emergency medical services provider, meaning whoever it is that the emergency medical services person works for. The statute doesn't apply at all unless either the chief or the provider has a written policy specifying the circumstances under which the responders are needed to respond to the emergency. And the policy has to say that the responders will be released as soon as practicable, and the employee has to give the employer a copy of this written policy within 30 days of notifying the employer of the employee's status as a firefighter or emergency medical services person. So there's some real hoops to jump through if you're the firefighter or the emergency medical responder has to jump through in order to even be covered by the statute, but it does provide some protection. I would expect that it would be an unusual situation when employers would want to penalize firefighters who are out there really, risking their lives and things. Anyway, the next piece of legislation has already been alluded to earlier today, and that's LD 183, and that's with respect to making Juneteenth, which is June 19th, but it's called Juneteenth. I have to confess, it's my own insulated upbringing, I'm sure, but I'd never heard of Juneteenth until the last, several months or so, which is just a function of my own, where I grew up and so forth. But anyway, Juneteenth, June 19th, is established as a state holiday in which all non-essential state offices are closed. It's added to the days that are not, quote, business days, unquote, under the state's banking laws, though banks may in their discretion remain open on Juneteenth or on any of the other days that are not, quote, business days under the statute. And Juneteenth is added to the list of, quote, unconditional holidays on which all public schools must be closed. So it's my understanding that a private employer, isn't required to recognize Juneteenth or frankly, any of these other holidays. But I would be a little careful because, of course, there are racial implications to Juneteenth because Juneteenth was first celebrated in Galveston, Texas, of all places, when on June 19th, 1865, Union soldiers came into Galveston, and the slaves were there declared free in Texas, in all of Texas, I gather, even though this happened in Galveston, under the terms of the 1863 Emancipation Proclamation. I am no historian and definitely not a Civil War historian, but it is interesting, of course, the Emancipation Proclamation was a famous thing, but it had no practical effect, at least apparently in Texas, until 1865. In any event, Juneteenth became a federal holiday this past June. The other statute that I will mention is LD 335, and that amends Title 22, Section 8110. Title 22, Section 8110 was already on the books, and it already required DHS to obtain criminal history record information for any staff member, including any job applicant who may be offered employment as a staff member of a children's residential care facility, and already required that such staff members or applicants be fingerprinted. This amendment simply broadens the statute to apply not just to children's residential care facilities, but to emergency children's shelters, shelters for homeless children, or group homes that provide care for children. Our next presenter will be John Hamer, and John is going to talk about some other new pieces of legislation. Thank you.
Thank you, Brent. Okay, I have a couple more, excuse me, I have several more statutory updates to give you, and we're going to start with the first one. Is LD 61. So LD 61 amends Title 26, Section 1843. Section 843 is the definition section of the main family medical leave statute. As you should know, it provides that a private employer who has 15 or more employees in one location, or 25 if you're a local government, must provide 10 work weeks of family medical leave over a 2-year period to an eligible employee who's met the work requirements, where the employee's been employed for at least 12 consecutive months. And this can be for a serious health condition of the employee, birth of a child, adoption of a child, serious health condition of a child, domestic partner, child, parent, domestic partner, sibling, or a spouse, for donation of an organ, or for the death or serious health condition of a spouse or immediate family member who's in the military and on active duty. So what LD 61 does is that it adds grandchild or domestic partner's grandchild is covered by the leave requirement for a serious health condition. So now if there's a serious health condition of a grandchild or a domestic partner's grandchild, it's an eligible reason for taking state family medical leave. The second statutory amendment is LD 610. This amends Title 26, Section 635. Section 635. It had provided, this is the provision that deals with recovery of overcompensation paid to an employee. So 635 had provided that an employer could withhold up to 10% of the net amount of an employee's pay without their permission to recover an overpayment. Overcompensation means any compensation paid to an employee that's greater than they're entitled to under the compensation system, but it does not include fringe benefits, awards, bonuses, settlements, expense reimbursements, commissions, or draws or advances against compensation. So there are these two major provisions, the 10% limitation, and then the definition of what is an overpayment. Now, this amendment alters 635 in 5 ways. The first thing it does is to define employer to include state and local government and any person acting directly or indirectly in the interest of an employer. This is really a clarification. I don't think there was any confusion before that state and local governments weren't covered, but now the answer is out there and they are definitely covered. The second thing it does is it excludes paid leave from the definition of overcompensation. So if paid leave, if it's made out, if extra paid leave is granted, then it can't be recollected through the 635 recovery provisions. Now, paid leave is defined to include sick leave, vacation leave, and comp time. So those are no longer considered a possible overcompensation area. The third, and perhaps one of the more important provisions, is that it reduces the amount of pay that can be retained without an employee's written agreement from 10% to 5%. So you don't need the employee's agreement to withhold 5% to recover these overpayments. And it may take a while for you to recover those overpayments, but basically the thought is that don't overpay them. Don't make that mistake and you won't have to worry about it. The other thing you can do, of course, is you can still get your written agreement from the employee and you can withhold whichever amount you agree to. If it's in writing, make sure it's in writing and signed by the employee. The fourth thing that this provision does is it sets a statute of limitation on recovery of overpayments. So an employer can only recover overpayments that occur within the last 3 years of the discovery of the overcompensation. So if you made an overcompensation and you just sit on it for several years and you don't do anything about it, after 3 years you will lose the right to recover the overpayment. And then finally, the LD 610 amends the statute to provide that the statute does not limit an employee's general civil remedies against an employer. So again, that's probably more of clarification, but if an employee decides they want to sue you for whatever, then this statute is not going to preempt them from doing so. So I've saved the most complicated provision, and I'm probably going pretty quickly here, but but they're pretty short. I have saved the most complicated provision for the last LD 1106. This is an amendment to Title 26, Section 621A. Now, this provision requires the timely payment of wages, full and accurate wages. Has to be within intervals not to exceed 16 days. So that's the payment period. You have to have your payments made within that period of time. And each payment must include all wages earned within 8 days of payment. Wages must be paid on an established date or interval that's made known to employees going forward, so that employees will know when to expect their pay. And it allows you to reduce an employee's pay with basically 1 day's notice to the employee. So if they're not covered by a contract and you are going to have a wage reduction for some reason, you have to have at least 1 day's notice. It's not terribly onerous, but that's a requirement. So what LD 1106 does, you probably should write this down. It provides that an employer may not, under any circumstances whatsoever, charge a fee for using direct deposit. Yeah, I know. It's hard to accept that one. It's pretty difficult and it's very complicated and confusing, but you cannot charge a fee for direct deposit. And the other thing that this LD does is nothing. That's the end of it. You just can't charge for direct deposit. So I'll let you let that absorb as Anne-Marie comes over here to give us the final updates. Thank you.
All right, wow, I've got a lot of paperwork here. So I just want to, oh God, well, it's broken, it's broken. I just want to follow up on one thing that John was talking about, and that is the grandparent leave. As you know, the FMLA remains near and dear to my heart. And so I've given this a lot of thought, and I want to be sure everybody understands that that change is in some ways a lot more significant than it may even sound, because what it does is it puts us back in a situation where we now have different leaves available under state versus federal FMLA. So you remember we went through this many years ago with domestic partner. And what I mean by this is state FMLA now recognizes leave for grandparents, but federal does not. And so the practical effect of that is that if an employee, if you're covered by both state and federal FMLA, so that meaning you have more than 50 employees, your employee could now potentially, within a 1-year period, take up to 10 weeks of leave for leave because of their status as a grandparent, which will not run concurrently with federal because federal doesn't recognize that kind of leave, meaning that they could take potentially another 12 weeks of leave in the same 12-month or calendar year period. Okay, just want to be sure everybody's clear about that. And please amend your policies. They should already have been done because that went into effect on October 18. If you have not changed your state FMLA policy, please be sure you do that. Okay, so the ones that I'm going to be talking about, the first one is what we've been calling ban the box. And what it really is, when I first heard that, I thought it meant ban like the giant box stores. But that's not what it is. What it is the law that relates to asking for criminal record or conviction information from an applicant. And as you all know, for probably forever, you've had applications that have words, something to the effect of, have you ever been convicted of a crime or a felony or whatever you've called it, check yes or no. And some have spaces where you can explain it, some don't. I think probably everybody at this point knows that you cannot ask for arrest information at any point. It's only convictions, but that now has changed as well. And again, this change was effective October 18. If you have not updated your application, make sure you do that immediately, because what this law now says is that in order to remove obstacles that preclude applicants with criminal histories from gainful employment, you are no longer permitted to have that section, that box on your application. So it prohibits you from doing 3 things. One is, excuse me, requesting a criminal history record information on an initial employee application form, which is what I just said. Number 2, stating on an initial employee application form or advertisement that a person with a criminal history may not apply, need not apply, or will not be considered for a position, or words to that effect. And 3, you cannot specify in any other way prior to determining a person is qualified for the position that somebody with a criminal history will not be considered. So what that boils down to is you are no longer able to ask pre-conditional job offer about a criminal record history. Although that's not completely correct either, because there are exemptions, there are exceptions to this, of course. Some of you are required to know about somebody's criminal record, conviction, or history or background. And so it says specifically in instances in which federal or state law, regulation, or rule mandates that a criminal conviction disqualifies an applicant from a position, imposes an obligation on an employer not to hire an applicant who's been convicted of a certain type of offense, or requires that you do a criminal history record check, this does not apply. So those of you who fall in that category need not worry about this. For everybody else, there are no longer any pre-conditional hire discussions. However, once you have determined that somebody, prospective applicant has been determined otherwise qualified for the position, or you are interviewing this person to make that determination, you may ask that question. So not on the application, but if you bring somebody in for an interview, or you otherwise make a determination that you're going to be offering a conditional job, You may then make the inquiry. Except that you can't just say, have you ever been convicted of a crime? You have to then give the applicant the opportunity to explain the information and the circumstances regarding any convictions, including post-conviction rehab. So this concerns me because, as you know, I and others have been harping on you for the span of my 22-year career now here to not ask those questions in interviews or anywhere else, because you may end up with protected information that you don't want and aren't supposed to have. But now that's changed. So if you want to know about somebody's criminal history, and of course you do, because you have other obligations like negligent hire and negligent retention, that really means you have to have that history. So you're not asking on an application, you bring somebody in for an interview, you may ask at that point, have you ever been convicted of a crime? And if they say yeah, if they say no, then you're done. If they say yes, then you have to give them an opportunity to explain so that you can then make an individualized determination about whether or not that really does have any impact on the job that you're hiring them to do. So as an example, if you work at a place where you have people drive for you as part of their job, but you are hiring this particular person as a receptionist, and in the interview you ask and you determine that that person has had an OUI conviction, maybe that you determine then that that's not directly relevant to the job that person's being hired to do because they're not a driver. And so maybe it doesn't automatically exclude them from being qualified for the job. So that's the determination you have to make. Where I get concerned about it is this phrase that's right in the statute that talks about giving them an opportunity to explain, including post-conviction rehab, because that's where you may end up with information about substance abuse, addiction, drugs, alcohol, whatever it is. In attempting to explain, you know, the applicant says, well, yeah, I had a DUI. However, I went through this program. I went to an inpatient program. I'm following up with outpatient treatment, and I'm good now. I mean, in one way, that's terrific. In another way, that's not good, because now you have protected, confidential medical information, and if you determine not to hire that person, you're now at risk that the person will say it's because now you know that I'm a recovering alcoholic or a recovering drug addict, and you didn't want to hire me because of that, not because of the conviction. So that's a little scary for me. But at any rate, that's what the law says, and that's what you have to do. So, so your tasks are review your application, make sure that it does what it doesn't do now, what it's not supposed to do. And I think it's important now that you be sure that if you are not the person doing the interviews, that you've trained whoever's doing them to make sure that they understand how this works. So if you have a supervisor or somebody who doesn't ordinarily interact that much with HR, doesn't have that training and experience, just make sure they know what kind of conversations they can and cannot have. And by the way, this does not preclude you. I don't see anything in here that precludes you from still doing the infamy criminal background check, but now at a certain point. So after you extend the conditional job offer, but that's probably when you would have done it anyway, because you need date of birth to do that, and you can't have that until after the conditional job offer. So I don't think it's going to change that process at all. All right, so my next one is the Act to Improve Consistency in Terminology and within the Maine Human Rights Act. That is very badly worded. I don't know if I did that or not, but at any rate, so there were a few changes to the Maine Human Rights Act, 3 in particular that I'm going to talk about. The first is just a matter of terminology. And so the Act has long recognized that gender identity is a protected category, but it has subsumed gender identity within the broader term sexual orientation. And so now what they've done is they've broken out gender identity as a separate category. The commission itself has said this is not, this isn't creating any new rights. It doesn't mean anything that it didn't mean before. We're still protecting based on gender identity. It has the same definition. It's simply a matter of taking it out from under this umbrella of sexual orientation and making it its own thing. I think it's a matter of respect, basically, for people that fall within that category, not to be subsumed within a different category. So that's what it is. Gender identity is still protected, of course. So check your policies. You may want to now, in your EEOC statement or non-discrimination, you may want to separate that out as well. And along with that, the Act has added familial status in the list of protected categories. Now, familial status has existed before, and it was defined in terms of living with or caring for minor children. But there is a change to that. So it's been broadened now, and familial status now also includes people who are living with or caring for adults who lack the ability to meet essential requirements for physical health, safety, or self-care. Essentially, they're not adults who are not able to otherwise care for themselves. So that's now part of the Act as well, and you should make sure that that's added to your non-discrimination statement also. And then the last change that I want to talk about to the Maine Human Rights Act is they have added a provision for victims of domestic abuse who have sought and received an order of protection. It is now unlawful to discriminate against an applicant who falls within that category. And the purpose, of course, is to make sure that employers are not choosing not to hire people who are in that terrible situation and may need time off for various court actions or what have you, and may be in bad circumstances. So you cannot discriminate on the basis of that either. Okay, so those were the two that I had listed, and then my next job is to sort of do a follow-up to any other legislation that we weren't able to get to. And so one of the things that I wanted to mention here is unemployment. So there were a bunch of changes to the unemployment provisions, and I keep hearing this buzzing. I think it might be in my head. I'm not sure, but at any rate. So there are a bunch of unemployment updates. I know I've done them for a lot of you in these legislative sessions we've been having this fall. I'm only going to talk about one because I think the rest of them, you know, they impact you, but they're not overwhelming. But this one is significant. And so you know, there's a section in the unemployment statute under which an employee who voluntarily quits and ordinarily would therefore be excluded from being able to collect unemployment, there's a list of reasons why they might still be eligible for unemployment even though they quit. And they've now added to that list, and the new category, it basically says that a claimant may be eligible for unemployment benefits if the voluntary quit was due to the unexpected loss of a child or elder care, not loss of a child, loss of child or elder care, for which the claimant was not at fault and for which no work alternatives such as changes in hours or a leave of absence or alternate child or elder care options were available, despite good faith efforts made by the claimant to resolve the issue and continue working. So there's a lot to that. So basically what I think this was in response to COVID and all the problems people are having with lack of childcare, lack of elder care, and essentially is saying, if I have to quit my job because my childcare provider is no longer available, then I may be entitled to unemployment even though I quit. Except that you as the employer have some control over this, because it also says that not only do I not have to be at fault for this, but there can be no work alternatives available to me that I rejected. So if I come to you and say, my child care provider quit, not because my child is bad in any way, but just because she quit, and then meaning that I don't have anybody to watch my kids, so I can no longer work. If you as the employer say to me, oh, but I can help you out, I can give you remote work, or let's talk about changing your hours so that maybe your significant other can cover some periods, or you have somebody else who might be able to watch them. If you do that, and these are good faith efforts, and I reject them, then I think that gives you an argument why I would not be qualified for these benefits, okay? Because it says specifically that the claimant has to make good faith efforts to resolve the issue and continue working. So that's out there. And then I think that pretty much talks about most of the legislative updates. There are a few bills that are being held over. And I always hate to spend time talking about things that don't exist, because we have way more things that actually do exist to worry about, and we don't need anything else that might never come to fruition. But there are two in particular that I'm going to violate my rule because of. Well, actually, one is the most important, because there was a long fight about this legislative session, and it did not pass, or it was withdrawn, but it is going to come back, as I understand it. And that is that law that was going to treat vacation time differently upon cessation of employment. And so you may remember that the proposal was that despite your current vacation policies and any decisions that you made about whether someone can carry it over or whether they're going to be paid out that time when they leave or any of those things, basically this would scrap any of your own policies and say, once they accrue it, they get it, no matter what your policy says, no matter what. And so I know Peter Gore and I did the seminar about it. We talked a lot about what this means and the financial impact on employers, which seemed huge. So it didn't pass, and but it is, as I understand it, slated to come back. So just be aware, because you may need to mobilize again if you oppose that. And then the other one that we talked a lot about was the increase in overtime thresholds for what creates and what supports an exempt employee, because those were proposed to go up fairly substantially. That's been held over as well, so I expect that will come back. All right, so I have a few more minutes before we have break time, and I thought what I would do, so I was thinking while my colleagues were talking about leave, and I put together this little chart as I was sitting there. And I was thinking about the leave that I've been talking about earlier, and so I wanted to go through 3 categories that you are likely facing, and what leaves you might want to consider when you have one of these categories. So the first one is if you have an employee who's out because they have COVID, and I'm sure we'll talk more about this when we get to our COVID section, but you want to look at so this is somebody who actually has it, not a family member, not quarantine. You want to look at FMLA. You want to make sure you're looking at the EPL and whether they have leave available to use under that. And you want to potentially look at whether or not they're a person with a disability who may need leave as an additional accommodation under the ADA. But and I'm sure you probably know this, but the FFCRA no longer exists, right? That was done, even with the extension, that was done as of September 30. So you do not need to worry about applying, even voluntarily, the FFCRA. We may or may not see another version of it. That's entirely unclear. Now that kids can be vaccinated, it seems like that addresses at least part of the issue the FFCRA was created to deal with, and so maybe not. But at any rate, it's not in effect now. And this is not necessarily an exclusive list, but these were some thoughts, and we have a few minutes, so I'll go through them. Now, if it's not the employee, but it's the employee's family member who actually has it, all right, not that they're afraid of getting it, but they actually have it, and the employee wants leave for that reason. So once again, you go back to FMLA, right? Not because the employee has a serious health condition, but because they have a covered family member who has a serious health condition. And the provisions about needed to care for are extremely broad. So you want to look at that, and then you certainly want to look at the EPL and whether or not they have any time available under that. And then don't forget about the main family sick leave law. I mean, I know there's a million of these, and some of them get tossed by the wayside because there's too many. But the main family sick leave law, it's not new. It's been around forever and a day. I've never seen anybody bring a claim based on it, but it's there. And that's that law that says if you have 25 or more employees, then the employee can use whatever time they have, and however you qualify it or quantify it, whatever the word is, whatever you call it, PTO or sick or vacation, doesn't matter. they can use that time to care for a family member who is ill. So they don't define ill in the statute. It doesn't give anybody any additional time. It just says you can use the time that you already have to care for a family member. So you may want to make a note that you're running that as well, just so they know that you know that it's there. And then if the employee goes out to quarantine, not necessarily because they have COVID, but because they're just their kid has a close contact or whatever the case is. So somebody's quarantining. So we know no longer the FFCRA, right? Not FMLA because they don't have it. So they don't have a serious health condition. Not ADA, again, because there's no disability, all they're doing is quarantining. Not the main family sick leave law because it's themselves and not a family member. But don't forget about the EPL, because now that the quarantining time can be unpaid, you don't want to fire somebody who's out because they have to quarantine, and you can offer remote work. But if that doesn't work out, you want to apply whatever accrued time they have, including the EPL, okay? And don't forget that, of course, there's always a comp component to these. Workers' comp. And so we've been dealing with that a lot, of course. I can talk at length about that when we get to the COVID section if we want to do that. It may apply. Most, if not all, the claims, at least outside the healthcare setting, are being denied as a matter of course, mostly because the burden of proving that it arose out of the employment and not somewhere else is just simply too great, I think. Although I do have one case working its way through the system with a very interesting twist, and I can we'll talk about that in the COVID section. So that leads me to we're running up now to our 11 o'clock break. What we're going to do when we come back is talk about COVID. At least that's what we're going to start doing. We have an hour and a half in our last session. We're going to do a roundtable, and so we're going to address COVID-related issues because we really felt like that was probably foremost in your mind at this point. We do have a variety of other non-COVID related questions. If we get to those, we will do those as well. But I encourage you not only to keep sending in regular questions, but especially COVID related questions so that we can look at them over our break and be ready to make sure we respond to whatever your concerns are when we come back at 11. So having said that, do we have any other housekeeping things I need to talk about? Keep the questions coming. There have been some really good ones so far. And we will then go into break and see you at 11:15.
I need to.
Hey, good one.
What if it's a male?
HR Barb.
Could be.
Oh, hi. So they didn't tell me we were back on. I want to let everybody, so hello, we're back. This is the roundtable portion of our discussion. We welcome your questions. We will be able to see them now. So as you ask them, we can incorporate them and answer them as we go. As I said before, first I'm supposed to tell you that we have a next winner of this handy dandy wine cup, which is empty. The one here. And that is HR Barb. And so congratulations, HR Barb. Hopefully there's only one of you with that name out there, but you are the winner. So good job. All right, now we're gonna spend however much time we need to of the next hour and a half talking about COVID. Woohoo! And so we're going to start out, but if we finish what we have to talk about and we don't have more questions from you folks, then we're going to transition into all the other questions that we've gotten that are non-COVID related, and we have a super fun game that Karen put together for us to do that. So before we do that, let's take a deep breath, and here we go with COVID. As you know, there are how many standards? I think 4 standards now that you're all dealing with, depending on what kind of employer you are and whether you're covered by one or more of them. There is the federal contractor mandate. There is the ETS, which of course is primary in everybody's mind right now. There's the Maine healthcare mandate from Governor Mills, and there is the federal CMS mandate. So we're all going to talk about one of those just briefly to make sure that you understand that there are 4 separate things that might apply to you, and that you're applying any of the things that that do apply. Just briefly, and it's hard to address any of this briefly, but when we were putting together what we were going to do today, the ETS obviously became front and foremost of what we were going to be talking about and helping you figure out how to apply all of the provisions of it. And now everything has changed. And so, as I'm sure that you know, in some way or another, the ETS is currently on hold. And so what happened was it was challenged in a variety of courts. The Fifth Circuit had addressed it late last week and issued an order indicating, as Josh had mentioned before, that they were temporarily halting it. Well, I don't know what all the terminology is, but eventually it became an order to stay the ETS. OSHA then issued its own statement as of November 12, saying that it was putting it on hold. It was not going to be enforcing it. That raises some confusion. Well, so at this point, a separate district court, federal district court, has been appointed. It's now the 6th Circuit, which will be hearing the arguments. They're trying to streamline it, but of course there's a lot to this, and so nobody knows what the time frame is, or at least I don't know what the time frame is. Eventually it will likely end up at the U.S. Supreme Court, so we don't know what's going to happen with the ETS and whether you will ever have to enforce it. But the question, of course, is we have deadlines coming up under it in the event that they did reinstate it, and because the first one is December 6th, and then you've got another deadline, January 4. And so there's been some discussion about, well, do we go forward with the things that we were supposed to do so we're ready in the event they undo the stay, or do we not do anything? And so that's one of the things we're going to touch on. But that's generally the status of the ETS. So while it did seem to be one of our primary areas of discussion, it's not really going to be that now. So now each one of the rest of us is going to talk about one of these other standards just to make sure that you understand what all these are, and then we'll talk about how they apply and other COVID things generally. So we're going to start out with, let's start with Brent, and I believe Brent was going to be talking about, I lost my little list here. You were going to be talking about the federal contractor mandate, right?
I thought I was going to talk about the Denver Broncos.
Yeah, we don't want to hear about the Broncos.
Before we start with that, I would just like to say that the four of us are all fully vaccinated, so we may take off our masks so you can actually see who is speaking.
Right.
And so that you can actually understand what we're saying, so
The unveiling.
that is why we're doing this. And
I've had my booster even, so there you go.
Wow, good for you.
All right. I'm just, there's not even close to enough time, nor would there make much sense to go into details about the
and the Broncos.
federal, well, no, that would make sense. But,
We don't want to hear about the Broncos.
Okay. But it wouldn't, can't really get into the details of the guidance for federal contractors and subcontractors, but I'll just try and give a little overview of where things stand now. There are some court challenges to this as well. I'm not sure what progress they've made. They're different because this is generated by an executive order of the president, and the executive order is not very long. It's well, you can, and it's, read it for yourself, about 4 pages long. But of course, it itself then generates among the agencies and the enforcement mechanism much longer documents, but it's contractual, whereas the OSHA tried by federal regulation to say, by regulation, here's what certain employers have to do and how they do it. This is contractual, and it's more like, well, if you want money from the federal government and by selling it goods and services, then there's already a lot of clauses in federal contracts that the federal contractor has to abide by. And now there's going to be another clause. And in fact, it is called the clause in this stuff. And the clause simply in federal contracts as, and there's a timeline. Obviously, this clause wasn't in the contracts prior to the executive order, which was issued in September. And then further guidance was issued later, so this clause wasn't in it yet. But the clause just simply says that the contractor or subcontractor shall, for the duration of the contract, comply with all guidance for contractor or subcontractor workplace locations published by the Safer Federal Workforce Task Force, the task force. And here's the guidance, and it itself is not very long. It's got some definitions to begin with, and then it sort of summarizes what it is. And then it provides links to other materials that then flesh out much more by question and answer what things will be, what the clause really imposes in these contracts on federal contractors. And the clause is supposed to be in any contract that's covered by the order that is awarded on or after November 14th, the clause is supposed to be in there. And so if anyone, today's the 18th? Today. If you're an employer and you get awarded a federal contract or enter into a renewal of one, as of today, the clause is supposed to be in there. Presumably the agency with which you're contracting with is supposed to have it in there. Prior to today, it was optional, but highly encouraged if the agency could get its act together to put it in there. One thing about this is that this obviously applies to large federal procurement contracts that go through what's called the Federal Acquisition Regulation. And if your company is one of those, I'm sure you're familiar with the Federal Acquisition Regulations, FAR. And even then, it's only contracts in excess of $250,000 by my reading, because there's a reference to a minimum threshold, and apparently that threshold by statute is now 250,000. But the executive order says well, not other, but all federal agencies are strongly encouraged to include the clause in any contracts anyway. So it is quite possible that even contracts that are not mandatory in terms of covered by these federal contractor guidelines and the executive order, even if it's not within that, a particular agency might follow the strong encouragement in the executive order and put the clause in there. So, so for example, one example is if you're a subcontractor who just provides products and that's it, under the executive order, it doesn't apply to you. But you could face a situation where for whatever reason, the federal agency with whom the prime contractor contracts says, well, no, you're going to have to include that in all your subcontracts, even if they provide products. I know that we're not required to do that by executive order, but that's what we're doing. It's way too early, I think, to see how that's going to play out. So basically, what they do is they define contracts very broadly. It's clear on its face that it applies to both federal procurement contracts that go through this FAR process regulations, but also to non-FAR contracts. And as I read it, even for the non-FAR contracts, they still have to be 250 grand to be covered. But you'll know because the clause will be in the contract. And if the clause is in the contract, in some ways it makes no difference whether or not it really is a contract within the meaning of the executive order or not, because all the agencies have the discretion to stick the clause in there anyway. And if you don't like the clause, then don't do business with the government, I think would be the attitude if they put it in there. What you need to do if you're subject to the clause, then that becomes a covered contract. You're a covered contractor. You have to identify your covered contractor employees. And that means any employee working on or in connection with the covered contract or working at a covered contractor workplace. And a covered contractor workplace is defined as basically any workplace under the control of the contractor where even if there are people who are not working on the government contract or in connection with it, if other people just happen to come in there or are likely to be expected to be in there, then the contractor has to take steps to enforce certain protocols with respect to them. The deadline, at least for now, for vaccination of covered contractor employees is January 18th, 2022. Obviously, mandatory vaccination of such employees is a big part of this, of the clause. There is an out if a federal agency has an urgent mission critical need for a covered contractor to have employees working, February 2022 and they haven't all been vaccinated yet, the contractor can apply to the agency and they can get an exemption for that. But in addition to the vaccination requirement, I might add that there is no, under the order, there is no testing alternative. But there is the religious and medical contraindication and disability exceptions that for employees, but there is not a testing alternative as there was in the ETS. But there's also requirements relating to masking and physical distancing in the covered contractor workplaces. And they in turn refer you to the CDC's publication as to which county by county are places in the United States with high to moderate transmission and low transmission and so forth. I went and looked, and not surprising, Maine right now is in the high transmission everywhere. So under these guidelines, everybody would have to, vaccinated or unvaccinated, would have to wear a mask in the workplace. Unvaccinated folks would also have to socially distance, but the vaccinated people don't have to socially distance. Don't ask me why, but that's in here. The employees have to show or provide the contractor with a list of their vaccination status. The contractor also has to designate a particular person to or persons to be in charge of making sure the contractor follows these things. The only other couple of things I'll mention is the contractor is required then to flow it down to the subcontractor, and the subcontractor is required to flow it down to the subcontractor. But the right now, at least, they're saying that in terms of enforcement, as long as the contractor is making a good faith effort to do it, they're not going to just come in and terminate the contract. As of now, even if this is still in effect in the beginning of the year, they come in, the stated protocols, they try to work with the employer to see if they can help fix it, get things going again, and termination of the contract is last resort, but of course is on the table if the contractor continually fails to comply or for some reason just can't comply. So that's a little overview.
All right, super. All right, now we're going to shift gears completely, and we're going to go to the state regulation under DHHS for healthcare, and John's going to address that.
Yes, and I'll keep it fairly short because I know that Josh had mentioned them earlier and discussed them as well. And I just want to tell you that I'm sitting here behind Brent, so I'm having a hard time focusing with the ponytail. It's quite something.
I know.
Imagine when it's purple.
I know it's going to be very distracting. So, at any rate, so the DHH regulations came out and they've been amended. This is in the Code of Maine Regulations 10-144, Chapter 264, if you want to look it up. But basically what has been done is that Section 2, immunizations required, has been amended. Except as otherwise required by law, each designated healthcare facility, which is defined in Maine, must require for all employees a certificate of immunization, proof of immunity, or an exemption for measles, mumps, German measles, chickenpox, Hep B, influenza, and now they've added COVID-19. So I did mention there's proof of immunity. Later in the regulations, it says that there is no proof of immunity for COVID-19 or influenza. So sorry about that. The next section is a new section. It provides that, again, except as otherwise part of the law, each EMS organization and dental health practice in Maine must also require, I added the also, for all employees, a certificate of immunization against COVID or documentation of an applicable exemption. So through those, and again, EMS organizations and dental health practices, those are also defined terms. So all of those groups are now required to either show the certificate or have an exemption. Now the exemption is basically in a different statute. In 22 MRSA section 802 provides that a medical exemption is available to employees they have to basically show that immunization is medically inadvisable. There's no religious exemption. We've talked about that before. And the third exemption under that section deals with Hep B only. So pretty much you're looking at the only exception being medical exemption. Any of those folks, and the deadline for compliance is passed, and DOL is out there supposedly enforcing this, but no chief administrative officer may permit an employee to be in attendance at work without either the certificate or the exemption. Let's see anything else in here. There's also no defined minimum period of danger for influenza, Hep B, or COVID-19. So those are things that take effect right away. I think that's all I wanted to say as the nutshell for the DHS regulations.
All right, and then Josh is going to address, just to complicate things further, the final rule from CMS, which was recently issued. And this is again, now we're back to the federal rule.
Yeah, and I'll be brief on this. I know that we've got a number of healthcare clients, and I know that a lot of them either have their own internal legal departments that have looked at this, or a lot of them have sought outside legal counsel to start looking at this. So I won't beat the dead horse. But the CMS policy, it's a little bit different than the state one that we have in a couple of respects. First of all, it's broader in terms of who is subject to it. So for instance, under the state rule, certain types of ambulatory surgical suites might not be covered by the state rule. They might, but they might not. Whereas they might be covered under the CMS rule, even if they don't fall under the state rule. So for the federal scheme, basically, if you're any sort of healthcare provider that accepts Medicare or Medicaid, if you participate in those programs and you are subject to CMS oversight, then you are subject to this rule. Generally what it requires, and I'm not giving any breaking news away here, is that employees, for the most part, be vaccinated against COVID-19. It does set some deadlines for that to occur. The first dose is supposed to be administered by December 6th, so that's coming up fairly soon. And then the final dose is supposed to be over and completed by January 4th of next year. So keep an eye on those deadlines. Another area where it differs from the state rule is the exemptions that are available. Like the state rule, it does have an exemption for medical issues, whether it's a disability or some form of medical contraindication. But it also has an exemption for sincerely held religious beliefs or practices. So that's something to keep in mind, particularly if you're subject to both rules. Keep in mind that there's a little bit of a difference there. To further complicate things, this is also the subject of some pending litigation. I believe it was just towards the end of last week, 10 states filed a lawsuit in federal court in Missouri to enjoin this rule from going into effect, which means basically stop it until we can get some sort of ruling on it and its legality. It was 10 states. Maine was not one of them. New Hampshire was, and a number of others. And the last I checked, which was last night, so who knows if things have changed, but the last I checked, the federal government had not been served in that suit and had not had an opportunity to respond yet. So nothing has happened in terms of court action in that case. But the states who filed the lawsuit are asking for a fairly quick briefing schedule to get some sort of ruling on an injunction here. That could happen sometime in the next few weeks. And obviously we don't know where the court's going to come out on that. So stay tuned if this potentially applies to you to get the latest updates on whether or not it's going to be going forward.
All right, thank you. So you've heard now between the 4 different provisions that all of the 3, well, the CMS, the ETS, and the federal contractor all recognize a religious exemption, but the main DHHS rule does not. And so I wanted to talk a little bit about this issue with religion because I've had a lot of questions about it. I think you folks have as well. So it just so happens also that earlier this month, the EEOC issued an update about addressing what religion means in this context and what you're supposed to do about it. So generally, and I'll enlist the panel here to talk with me about this, but generally Title VII recognizes an exemption for a sincerely held religious belief. I know a lot of you have heard about this in the past, have grappled with what does sincerely held mean, and you know that overall pretty much anything is accepted as long as the employee sincerely believes it, whatever that means. But in this situation, I think in more than almost any other sort of topic that we've seen with regard to religion, it does not recognize a, let's get the language here, objections to COVID vaccination that are based on social, political, or personal preferences or non-religious concerns about the possible effects of the vaccine. Those are not religious beliefs, according to the EEOC. So, Brent, I'm going to put you on the spot. How does an employer, what am I supposed to do? If my employee comes to me and says, I don't believe in all this, no one's going to tell me that I have to be vaccinated, and by the way, I have a religion that tells me that I don't have to be. So what am I supposed to do?
Well, it's a quiet but I think in accordance with the guidance as well, you are permitted to push back a little bit. And because in what you just said to me, you said a couple of things that are pretty clearly not religious, but then you said, but it's basically against my religion anyway. And I think the employer is permitted to at least ask what religion, what belief, what observance, and how is it in conflict. And if the employee can't do anything more than just say, I don't feel comfortable talking about it, it just is against my religion, it's a sincerely held thing, then this is why we're having a roundtable. I think the employer might well want to
Sorry, I didn't mean to interrupt.
oh, right. He's a professional or volunteer actor, so he's saying I should be
Did you tell him to look at the screen?
I was trying to be surreptitious about it, but
I'm trying to do you all a favor. I'm doing it a ponytail.
Right. Nobody wants to see the ponytail.
Anyway, so I think, a more prudent employer would just accept it at face value and move to the next phase of the analysis. When I say more prudent, maybe a more risk-adverse employer, and just move to is there a reasonable accommodation that doesn't impose an undue burden? And if there is, great, fine. Or if, and it doesn't really matter if it's, sincerely held or not. The guidelines do, and I won't read from them, and I'm, do provide some examples of other things you might be able to ask about and whatnot. But it's not a comfortable situation, but it's one that's likely to be happening in the next several months in a way that we've never seen religious requests for accommodations before.
And the EEOC does actually in their guidance point out ways in which you might assess this request in terms of whether or not it's real or not real. And so, for instance, they say, has the employee acted outside the scope of what they're now saying is their religious belief? But keep in mind, you can develop a religion overnight and it still potentially has to be accommodated. Or is the timing suspect? And I think that's the big one, because if I've come to you and said, I'm not comfortable wearing a mask, I don't want to do this, I want to work remote until I don't have to, and you say no, then all of a sudden I say, oh, well, now, by the way, this is against my religion. So the EEOC is recognizing that maybe you can take that into account. Now, the standard for determining a religious accommodation is also different than disability. And Josh, you want to address that a little bit?
Yeah, so the standard in addressing a requested accommodation for religion is whether or not it imposes an undue burden, but it's a different undue burden analysis than what you would deal with in the disability context. And so the question, when you cut to the heart of it, is really whether it would impose more than a de minimis burden or cost on the employer. And that's not necessarily just financial cost, although it can be. It can be operational costs and other non-financial aspects that they take into consideration. So it's a much lower bar to meet in order to establish an undue burden in the religious context than it is to meet in the disability context. Again, because you're really looking at, is it more than de minimis or a minimal burden on you?
And so Brett raised this in his discussion, you know, for the medical exemption, you are charged with getting very specific information from an employee's physician to support that exemption. But what about religion? So John, I'm going to put you on the spot since you're my husband and I can. What do you think about saying to the employee, well, I have to have a note from your religious leader that you're not allowed to have this?
I think that you're inviting major trouble because the religious leader may give you a burning bush or something like that. I mean, who knows?
That's why I do not ask him questions.
I would suggest that you not ask for a note from a religious leader. I would suggest that you keep Anne-Marie and the rest of us on speed dial. I think that you can certainly push back a little bit to make sure that it's a real thing and not something that's just designed to circumvent the answer of no, you have to get vaccinated or whatever. But in the end, you need to be very careful, I think, because it takes very little to file an human rights complaint, and it takes a very lot to defend them. And it's probably not worth the time to try to fight it too much.
Yeah, I think we all agree with that. And in fact, the EEOC, along with their guidance, they actually have a religious accommodation request form. So you can get that off the EEOC website. I'm waving it around here, but that's what it looks like. And it actually does go through, it asks them to identify it and describe it, and then asks for what they're looking for accommodation. What it does not do is say, have your leader fill this out and confirm your religious belief. So without belaboring the point, we just want to talk about that because there have been a lot of questions. Now, to my wonderful staff over here who's helping with these, I've seen questions pop up and then they go away. Can we list them so that we can actually see them, or?
Yes.
And while we're doing that, can I just add to that
Yeah.
last thing? Not only should you not ask for a note for the reasons that they've already said, but even if you were to ask and the employee comes back and says, I wasn't able to get a note from my pastor or whatever, that wouldn't let you off the hook, because the law is fairly clear that somebody may hold a sincerely held religious belief, even if it's not a mainstream belief within their own religion. So for example, let's say you're Catholic, and the Pope comes out and says there's absolutely nothing wrong with Catholics getting these vaccines, it is not against our religion. You might be Catholic and you might still be able to meet that standard of showing it's against your personally religious beliefs to take the vaccine, and that would suffice. So just another reason why I don't go down the road of asking for notes or anything like that.
The individual might give you a note from themselves saying,
Right.
I'm the right person to ask.
Right.
That's right, because they can be a religion of one. There's no prohibition on that.
Traditional Protestant, tenets, as I understand it, is, the individual has a relationship, a direct relationship. It's not hierarchical, at least in some traditional Protestant religions. One reason also to call the lawyers when you get this is, if nothing else, we can serve as sort of a outside eyes and ears on it to see how it sounds to somebody who, you might sort of have dealings with this employee in the past, or you might look at it a little differently because of the culture of the particular employer, the size or whatnot, and it just might look and smell different, to an outside, observer, where we might be like, you're thinking of what? You're thinking of doing what? And so that's apart from the legal, I guess, certainty, because there's not much legal certainty in these situations.
True enough. All right, so we have one question on the screen about the OSHA ETS, if it goes forward, and I can answer this fairly in short order. Do you, where does it? It just disappeared. I'm like reading it and it's gone. Where does the ETS fall in terms of providing or compensating team members for required weekly testing? So it's very clear that while you have to pay up to a certain time period for the vaccination, you do not have to pay for the testing. And the supposition behind that is that it's meant to encourage mandatory vaccination as opposed to testing and masking. So there is no actual requirement that you provide for the testing. Do you have to provide transportation? No, you do not, period. At least as of now. I mean, everything might change when it actually comes back to us. So, all right. So now just
Here's another one, Emery.
Oh, if someone has, can everybody see these, or should everybody can see them? Okay. Someone has asthma and is unable to wear a face mask due to this, and they're not vaccinated. They will still have to test weekly, but what about? So I'm a little bit reticent to answer all the questions based on the ETS, since we have no idea whether it's going to come back at all or what format it's going to come back in. So I think as long as the group agrees, I think specific questions about the ETS maybe we'll hold, and then if it does come back, we'll be ready to tell you all about it. Except that I do want everybody to weigh in. So now you're in a quandary because this exists and now it kind of doesn't exist, but it has deadlines that exist and it's unclear. I mean, presumably they're not going to be enforced as they are now because we may not even have a decision before then. But if I'm an employer, what do? I'm supposed to start this list of all my employees and their vaccination status and take copies of their cards. Do I do that or do I not do that?
Don't take copies of the card. I suggest that you make a list and just check them off and then say you keep your card, so you don't want that kind of record in your possession. That's a place to start.
Well, is this a general question of, it looked like for at least 2 weeks, I was going to be required by law, or at least by OSHA standards, which is a law, to have a pretty full-blown mandatory vaccination or I could pick alternative where you also would have testing as an alternative, whatnot. Now that that's gone, should I just sort of pretend like it's coming back and start down that road right now anyway, or B, forget about whether it's coming back or not, or just as an employer have my own policy?
That's exactly what I just asked.
Okay. All right. Well, that's what our lawyer does, right?
So now let's answer the question.
Well, okay. we know the question.
All right.
Well, I'm going to give you the answer.
Okay. All right. We're ready.
The answer after that. I've come to believe, and this is, the word polarizing is used so often, but it is true. I mean, you can hardly say anything about these things that doesn't at least get somebody riled up. But I'll wear my political allegiance sort of say. I personally think that vaccine mandates are a good thing. But in terms of counseling employers at this point, unless the employer, for whatever reason, has its own real sentiment about this, for whatever reason that might be, I would just not have mandatory testing, mandatory vaccine, any of that stuff until I was required to do it by law.
Okay. So, all right. So now the listing that we were talking about before, that's if you do have the mandatory policy. And the question is, do you want to make the list and show everybody's status? So let's say an employer has already made their own personal decision, regardless of the ETS, that they're going to require vaccinations. Josh, do I have a list? Do I not have a list? Do I want that in any written form?
So if you've got your own voluntary policy requiring vaccinations with all the appropriate exemptions. Somebody has to presumably be in charge of verifying that people have complied with your requirement. So that would be somebody in HR, or there should be one delegated person or one team of people, I would say, that would verify vaccination status with employees. The EEOC guidance is fairly good on the fact that getting verification is not prohibited. You're allowed to do that. So I think that's fine for you to do, and you should do if you actually want your policy to be followed. But where I would probably draw the line under a voluntary policy as compared to the OSHA ETS standards is, like John said, I would not take the next step of taking and keeping copies of medical records or vaccination cards at this point. I certainly wouldn't be publicizing any lists. You might have your own internal notes about who's vaccinated and who's not, but I would not let that leave very many people's hands, and I wouldn't be publicizing that and giving that information out because that is arguably confidential medical information. And just from a morale perspective, employees probably wouldn't take too kindly with that being posted on the lunchroom wall. So that's my initial thought on it. And in terms of the standards themselves, in terms of what do we do while things are in limbo, one of the requirements under the ETS is a pretty hefty policy that's in place in terms of how you're going to handle things. So if you have the resources and if you have the time, which I understand not all employers do, it might make sense for you to at least get a policy drafted and in place so that if the ETS goes forward, you have it ready to go. But you don't need to necessarily implement it. You just have it on the back burner, so to speak, so that you've got one step completed if and when the court signs off on the ETS.
Yeah, I agree. That makes sense. And if and when you are charged with doing this, I've thought at length about how to maintain the information about the documentation for the vaccination. And I think that because it's a confidential medical record that has to remain confidential, at this point, I'm thinking you would do it like you do I-9s, and you have one binder with your listing of all your employees and copies of all their vaccination status that's kept locked, confidential, with very few people having access to it, as opposed to taking copies of all that stuff and putting them in personnel files where more people would be able to see them. Plus, if that meant if OSHA ever did come in and say, I want to see that you've complied with the ETS, you just pull out one binder, just like with the I-9s, and say, here it all is.
But not to have the actual vaccination cards in that binder, right?
I would have copies of them.
You would?
Well, because the ETS would require it as of now, and so I think if you were, but I agree, for now, I wouldn't do it. But when and if you are required to do it, that's the format that I would put it in.
And if there's one thing that COVID has taught everybody is to be flexible, because there will be undoubtedly many changes before the ETS become finalized. And yeah, that's it.
Okay, so now just to hit on some of the other questions that we seem to get a lot of. Suppose I have an employee, and you've seen a million different versions of this, but what if I do have my own policy as an employer and say I want everybody to mask, and an employee says to me, not going to do it, and they don't raise it as it's not a religious issue, it's just it falls into the social, political, whatever, you're not going to tell me what to do. What do you do with them?
I'll be the bad guy here. From my perspective, it's useless to have a rule if you're not going to enforce it. So if you go so far to make the decision, we are going to require this. And again, as long as they're not, asking for an exemption and qualified for an exemption, and they're just thumbing their nose at it because that's what they want to do, I would discipline that employee. And if you have a progressive disciplinary program, which I assume most of you do, I would work through that. So you start with a verbal counseling. If they don't get their act together, you move to the next step, which is a written warning or a verbal warning, whatever. And I would just continue through so that your policy actually has teeth and your employees know that you mean what you say.
I would actually add to that it's probably worse than useless to have a policy that's not being applied and enforced uniformly. So it's a difficult thing because, employees, good employees are hard to find these days. But maybe one way of handling it is to put down in the policy exactly what will happen for violations. And doesn't mean that you can't have some wiggle room in terms of the finalizing the discipline. But if you let them know up front that if you do not come to work wearing a mask, first time you get a written warning, second time you get a suspension, third time you will be dismissed, then you can just say to them, here's the policy, you know what's going to happen, and it takes a little bit of the pressure off them.
All right, but here's a twist. Plus, I was just thinking, we're gonna apply progressive discipline to the child.
That's what I was thinking.
Because it's not working any other way. So we're gonna do verbal warning, written warning. And then I don't know what.
If you're like me, you might have to jump right to loss of TV.
Right. All right, so here's a twist though. That's fine to apply progressive discipline. I completely agree with you. But here I am, employee who refuses, and now I'm on your work site. And the rule is wear a mask. I'm not wearing one. You called me in, you said you're gonna get a verbal counseling for not wearing a mask. I say, I don't care, I'm not wearing one. You're not letting me stay there though, right?
No,
Because now I'm unmasked and everybody else sees me.
I agree.
I agree
That
with that.
person should be sent home.
So you're gonna send them, now so then I'm gonna say, well, how are you gonna pay me? What leave do I get?
None, it's disciplinary.
You get
Really?
unpaid bad employee leave.
What if I have EPL?
If they've got that available, I suppose.
See, now that's
I would
interesting
disagree
though.
with that, because I think EPL is, you can take EPL for any reason. So you can take it for sick time and you can take it for vacation time, but a temporary suspension or even a short-term
Disciplinary.
suspension is different.
Yeah, I think that's interesting. So if it's
Yeah.
disciplinary and that's why I'm sending you
That's
home because you refuse to comply, am I entitled? What if I have, vacation time or whatever, EPL?
I mean, an
Not-
employer can decide
Yeah.
to allow that, but I don't think that they're required to, because it is disciplinary in action in
Yeah.
nature, and to allow them to take vacation time, or whatever, and get paid for it, it's really,
Kind of defeats the
Yeah,
purpose.
I agree with you. I'm
So-
sold.
So what if your employee comes in and says, all right, not in your face kind of way, not in a nasty way, but just, I really am not gonna wear a mask. It's not medical, it's not religious, I'm just not gonna wear one. Can I have leave? Can I just take a leave of absence until this whole thing is over? Because I've heard that about 100 times.
I think that the employer,
No,
I think that the employer can consider that if there's a mechanism for extended leave, but the person would probably need to be aware that if you want to take unpaid leave for an unspecified period of time, your job may or may not be here for you when you decide you want to come back. But that makes it easier. You're having an agreement about whether the person is going to be on site or not, and it avoids the whole disciplinary issue. So maybe the employee at that point will just say, maybe this employment's not for me, and then they can separate.
Brent, did you have something to add?
no, I agree.
I was gonna say I'll be the bad guy again. You certainly can do that if that's what you want to do, but if it were me practically, I might be more, if I'm the employer and I understand I'm not, I might be more inclined to say, well, this is the requirement of the job, and if you're telling me you're not gonna do it, then that's your decision to make, but you're gonna have to live with it, and we're gonna find somebody else who will do what we need to do. And for me, I think practically speaking, it's just problematic, if not administratively burdensome, to have people on unspecified status for who knows how long.
Right, and if you do, and I agree in the sense that the employer is permitted to make this, and I won't use the word accommodation, but this, right, for this person. But also, so suppose the employer says, yeah, okay, it's fine, you don't have to come in indefinitely, and then either hire somebody or have somebody else doing that job, and now suddenly things change and the person wants to come back. It's not very fair to the person who's been doing that to say, I mean, the person's been working there to say, okay, you're out now because so-and-so has decided, he or she or they, or, it's gotten to the point where it's.
Don't go there.
I won't go there. I'm just saying, it's like, I'm always afraid I'm gonna
We're gonna talk about that in the general.
Next question.
Next question.
Well, no, I want to say something to support your, I'm supporting you. Because I agree that I think what John said is you put them out, but there's no job security. And I would write a very firmly worded email or letter saying, you can be out for, if that's what you want to do, and you can be on this unpaid administrative leave, but your job may not be here. And we're not going to hold it open, and we're going to fill it, because if I didn't need anybody in that job, you wouldn't be employed in the first place. Because it's unlike an accommodation, right? Because if it was because of a medical reason, you'd have to keep my job open, arguably.
And I just wanted to point out that there are a number of public sector employers who may have policies for extended unpaid leave as well. And so in that situation, the employee could come to you and request one. It's probably discretionary whether it's granted, but there's probably a policy that will address it as well.
Well, that's a good point, because what if, I mean, shouldn't they check their policies to see, because a lot of employers do have a handbook policy that says we recognize unpaid administrative leave for whatever reason. And so if you have that, that may apply to this person. And if you don't apply it, then God knows what kind of discrimination claim you might get, right? So I think it's definitely a case-by-case situation.
We
all
have
right.
2 questions that relate
Oh,
to this.
good, okay.
So,
Under CMS, what is suggested if a coworker refuses to work with someone who's not vaccinated? Also under CMS, plus the employer pay for. So that's specific to the, I think you had talked about that. Can you address either of those, or do we want to?
I'm gonna hit the pass button.
All right, let me see. I've got some info about the CMS here. I'm not sure, though, that this is really makes a difference whether it's CMS or not. I mean, I don't think, as far as I know, the CMS guidance doesn't say anything about paying for testing. And in fact, it doesn't talk about, because it requires vaccination, right? So testing isn't an option under CMS. And then, so let's talk generally, not just under CMS, but what if a coworker refuses to, so you're not vaccinated, Brent, and I know it, and I'm not going to be around you. And so I go to the employer and say, you have to make him leave or move me to a different area. What do you guys think?
Well, presumably there'll be some other precautions that Brent will be taking, whether it's social distancing, masking, testing, in which case I think the response is get back to work.
Well, I mean, we might work in a situation, you know, we're in the kitchen, you know, cooking, or somewhere, and I'm not vaccinated, and you're not comfortable working next to me. And so I guess my first question would be is, on what basis are you not comfortable?
Yeah.
Because if you have some sort of underlying medical condition that could be classified as a disability, then I need to make an accommodation for you, which might be making me go away a little bit. If it's simply because.
Oh, wait, let's complicate that. So let's go with that scenario, but.
God, I'm glad she wasn't my law school professor.
Let my kid hate me. But suppose you have your own medical condition and you can't be vaccinated.
Right, well.
Does that make it, because now you are entitled to accommodation potentially. I want an accommodation because I don't want to be near you.
Well, if I'm posing a significant risk to your health or safety in the workplace, and that can't be accommodated by reasonable accommodation, then I'm not eligible for that. So the employer has to get rid of me.
Ooh, but you have a disability and that's why you can't be vaccinated.
Well, same thing though, is that if so if I can't be vaccinated, then, but the question is do I qualify for an exemption? Well, I am disabled, and is it because of my disability that I'm not vaccinated? Okay. So then, is there a reasonable accommodation that eliminates the significant risk? And this is where I think it's brutally difficult for the employer, because when I read the EEOC's guidance this morning, and it talks about significant risk, and it talks about the things that the employer is supposed to look at, you know, individualized assessment based upon the most objective, up-to-date medical evidence and the size of the workforce and yada, yada, yada. It's almost asking the employer to be Dr. Shaw and make these conclusions about what is and is not a significant risk, when even that is significant risk. What does that mean? I mean, I once, years and years ago, I had a case that went to the US Supreme Court where a local dentist believed that it was a significant risk to him to fill the cavity of a HIV positive person in his office. And we spent years and years arguing about what was and is not a significant risk. Is it 1 in 10,000 chance of fatality, a significant risk? 1 in 1,000 chance of fatality, a significant risk? Under certain many agency guidelines, Food and Drug Administration, whatnot. For example, if 1 in 500,000 people drop dead if they had an aspirin tablet, that would be deemed a significant risk, even though it's 1 in 500,000. But if the risk of transmission of COVID in the workplace, if you wear a good mask and you socially distance, I don't think anybody knows what the answer to that is. And yet the employer is being asked to sometimes have to try and make some decision based upon their perception of what is and is not will be a significant risk.
If I'm the employer in that situation, I'm going to be pretty reluctant to can the person who can't get the vaccine. And I would think that through some combination of measures, you could probably put together some package that makes things as safe as can be, whether that's masking, testing, sanitation, social distancing, whatever combination might work, I think is probably going to do the trick in terms of the substantial risk thing. And then the question comes back to, okay, well, what do we do about the person who is vaccinated but is not comfortable working around the person who's not vaccinated? And that's when you look to, well, can we move their workstation? What else can we do to accommodate them? But firing somebody would be something that I would be pretty reluctant to do in that scenario.
All right, if you're gonna be reasonable, then I guess you have to take a look at it, depending upon the situation and what their business is and whether there's any way. I mean, from a practical perspective, maybe you don't want to even have that fight. Maybe there's some easy way that you can have these two people not work together, and it might just save you some headache to do it that way. And then say get back to work.
I think I would also go back to the CDC guidance, because that really is the place that I keep coming back to consistently, and look at what that says about what's a safe environment. So if it's saying face masks are recommended and social distancing is continued to be recommended, and then that's their threshold for safety, then I may decide for I can't remember who was who anymore, but for the person who said, I don't want to work next to a non-vaccinated person, I think my response might be, well, as long as they're adhering to our rules for non-vaccinated people, which means masking and distancing, then they're meeting the standards. And if you want to move, that could be an option for you, but we're not going to take action against that person who's complying with the policy of the CDC. We have other questions.
A few more.
Okay. Cleaning vendor to medical buildings. Customer wants a copy of our employees' service and vaccination. No. What is that?
I don't see any problem with a copy of the employees that service them. So if you have a cleaning crew that goes into a building, I want to know who your employees are under the contract.
I'm reading this to say a copy of the employee's vaccination card.
Well, there are commas, so I think the next step is whether you can get a copy of their vaccination card, and then I would agree no to that.
I think you can tell them they're all vaccinated and leave it at that, but I would not produce a copy of the vaccination card.
And to make it interesting is if that medical building falls under the state mandate, they have an obligation to make sure that their vendors and contractors who are coming into the facility are vaccinated. So they are certainly allowed to ask and get verification of it through one mechanism or another.
Okay, if we do not provide religious or medical exemption under CMS, is it considered a termination or we accept a resignation? Does that mean somebody has asked for one of those exemptions and you decline to give it to them for some particular reason? Maybe we could get some follow-up from that person. Unless, I'm not clear on, does anybody else want to address it as it is now?
Well, at least under, say, the state regulations, if you're a healthcare provider and the person decides they don't want to get vaccinated and they don't have a medical exemption, at that point, I'm not sure that it matters if it's a termination or resignation. If the person agrees, then they have a resignation, and if they don't, then you terminate them. I think that the impact going forward probably is going to be minimal. They still would have the right to apply for employment.
We've been playing this game though with a lot of employees for some reason in COVID more than any other time I've seen it. And it's almost like this chess game about, are they gonna force me to terminate, or am I gonna call it a resignation? And in fact, we went back and forth with one employee saying, I accept your resignation, and they kept saying, I'm not resigning, but yet I'm not coming to work. And I think it does come down ultimately to unemployment entitlement. But frankly, I think the standards that we were accustomed to seem so far out the window that I don't think there's any way to even gauge whether or not unemployment is going to be awarded. And in fact, it seems likely that it will be in most situations.
If a person refuses to get the vaccine and that's the cause for the separation, is that voluntary? I don't know. Maybe someday we'll find out. So I think we completely avoided that question.
All right, did you say there was another one, or was that it?
Two more.
Okay. Does the burden of costs fall the employer under the main DHHS? I'm not aware of anything in the ruling that requires the employer to pay for that under main DHHS. Do you folks?
No, I think that's an individual requirement, and the vaccination actually is free anyway, so.
Right. And there's no,
time.
You do it on your own time.
right.
Unlike the ETS, you don't have to pay for any particular time for them to go get it. Although, I mean, if you apply general wage and hour rules, if you're requiring it and they're going on work time, I think you do have to think through whether or not you're going to compensate them for that time.
Yeah, I think it's likely, I'm gonna violate lawyer rule number 1, which is don't think out loud, but if you're requiring it and you're allowing them to go get it while they're on the clock, then my gut reaction would be probably that's gonna be compensable time.
Yeah, I think so too.
And
It's not such a long period of time,
Right,
really.
right.
maybe you're just
Right.
better off as a practical matter, covering the cost of a few hours. You can get it pretty quickly now,
Right.
it's my experience.
Yeah.
It doesn't take 4 hours or.
Now, the day off you need after the vaccination because you're not feeling well, that's a different question.
And just so everybody knows, none of these rules that we've been talking about address the booster. As far as I know, it's not a piece of what's required by any of these different standards, at least so far.
Correct.
Right.
This is the last one, it's 2-part.
Okay.
Email your WH.
It's a cliffhanger.
All right.
Yeah.
Oh my goodness.
No, I don't think you need to. Is it reasonable for us to have COVID card copies to prove that the person on the work site has either the immunity card or an exemption? I think that you can take that information down and you can have the person, you can write an affidavit. I personally witnessed this person's card and they have been vaccinated or they have provided or they qualify for medical exemption, and then that's should be the end of the inquiry.
And just to know, that's different under the ETS as it exists now, or in whatever form it is, and it does require them. So we'll see whether that comes out.
And the question asked about immunization, and just to reiterate what John had said earlier, not immunization, excuse me, immunity. The regulations do allow proof of immunity for some diseases, but COVID is not one of them. So you
COVID
can't,
and flu are both
yeah, you
exempted.
can't have somebody come in and say, I'm immune from COVID because I've already had it 3 times and I've got natural antibodies. That's not gonna cut the mustard.
You're Rogers' defense.
Right, it has to be vaccination for COVID.
Yeah, after the second time you had it, you think you figure that out.
Right.
All right. So this was a clarification of what we were talking about a second ago. They applied and we denied the religious exemption.
My gut reaction to that is if they applied for a religious exemption and you denied it and they resign, and if they're going to make literally a federal case out of it, like a lot of people do, my supposition would be that they would claim that it's a constructive discharge, that they had no choice but to resign, and therefore it's effectively the same thing as firing them.
So the other alternative is what we were talking about before, which is you tell them to get vaccinated. They say they can't for religious reasons. You say no go. And so instead of terminating or having a resignation, maybe you consider at that point putting them out on unpaid whatever leave without holding the job open. Although oddly enough, that could also be considered a form of a reasonable accommodation for the religious exemption. So
It also could be described as a adverse employment action. They don't want to go.
well, right. Yeah.
Just thinking out loud.
Yeah. Okay. All right, so we're at about 12:20, and which means we have a little less than a half an hour to go. So Karen has done a lot of work for us on this
Thank you, Karen.
super fun, I mean, just generally, but also, where do you see this? So I'm gonna,
And while she's bringing that up, it is fair to thank Karen and everyone else who's worked on this backstage, and that's including
absolutely Mark and Eric and
Mark and
Brooke.
Eric, Brooke, and consultants who I can't remember her name.
Ashley?
Ashley.
So thank you all.
Yes, I agree. All right, now.
You get a spit.
God help me. This is the wheel of questions. And so we're going to spin, and when the number comes up, somehow a question's going to appear on the screen, and then we're going to have to answer it. So this could be fun. All right, I'm going to just call me Vanna. Here we
I
go.
like my vow.
Oh, so.
Number 4. Look at that. What can you give for a reference?
This is
Can
a
you
good one.
be honest if past employees were always late or were not good at their job? I would love to answer this, but I'm gonna open it up to the
You'll have a
panel.
chance.
I would say that you can be honest. I believe that there is a provision somewhere, and I can't put my finger on it, that does provide you immunity from
Sort of immunity.
qualified immunity.
Well,
You get an idle.
It's a
Has to
good
be in
faith.
good
You
faith.
get an idle.
It's a good faith.
right.
My take on this, and what I've been asked this question, the advice I usually give is, while there is immunity for good faith, I think the best practice is name, rank, and serial number, which is, here's the dates that they worked, here's the position that they worked, and that's it. My rationale being simply, even if you have a good faith immunity defense, there could still be a whole lot of time and expense and headaches involved in proving and succeeding on that defense in a defamation lawsuit or tortious interference lawsuit. So just doing the name, rank, and serial number, I think, is a much easier way to deal with that. And usually,
That sends a message too.
yeah.
And you should funnel it, all requests for references or something, if you can, should be funneled through one person even, or one office at least, so that other employees, if asked, or at least should understand that they're not to say anything. I mean, it's sort of an age-old question. I mean, 30 years ago, I don't know that many employers would give it a thought, because a lot of even former employees got bad references. But then employers started getting sued for defamation whenever they gave a bad reference, and the cost of that was, very costly. And so he ended up with a system nowadays where I suspect most large employers at least just do name, rank, and serial number.
So here was my immediate thought about this, and I agree with everything everybody said, except that I would wonder if you, employer, have done your job in documenting the problems with this person, because if the person knew that they had problems with consistently being late or not being good with their job, they ought to know that. They ought to know that that's the situation. And so I would say, well, why are they putting you down as a reference if they know that they were terminated for bad conduct or because they were a bad performing employee? And so that raises, of course, this age-old issue about make sure your performance evaluations are correct and you're bringing up the things that need to be brought up, so so people are aware of this. Okay, here we go again.
That's better. Last one was a little.
Want me to give it some more force here? Did I land on 4 again?
Yeah.
No, it's on 3. Megan, when is LD 610 effective?
Which one's 610?
I don't have my materials in front of me. It's in that black binder right there if you want to grab
Is
it.
it over here? It's right there.
My recollection is that all of the legislation this year was non-emergency, which means October 18.
610. This is not emergency.
So October 18.
In other words, it's already in effect.
Okay, here we go. 7. This is fun. With all the legal holidays, do I have to pay for the time off? Should we all do it?
It depends.
Well, now you have to explain.
So, it depends on your situation. So do you have a collective bargaining agreement that speaks to that? You might, and if so, you've got to follow whatever the CBA says. Generally speaking, if you don't have a CBA, you don't have to give paid holidays off. People might have paid time off available to them that they elect to use, but generally speaking, you don't have to do that as a matter of course.
I came close to saying this, but then I think I forgot to say it on the new Juneteenth holiday. Let's face it, there is, I'll say, a racial framework to it. So if you're an employer and you give paid time off for all the other legal holidays except for Juneteenth, maybe someday I'll learn how to say that. I'd be a little wary of that.
I agree.
Frankly.
I agree completely.
Follow up on
You're not
Juneteenth.
required to make any holiday a paid holiday. It's completely up to your personnel policy or your collective bargaining if you've negotiated it. So if you wanted to make New Year's Day a work day, go at it.
Yeah, Scrooge. Well,
And
you
then
did
the follow
say
up, Brent,
Christmas.
to the Juneteenth.
Right.
Um,
We are not required to be closed, but, no, you're not required to make it a paid holiday.
I understand it's a paid holiday from the state, so state
Right.
employees will get it
Right.
off and paid.
Right.
And there may be, offices that follow the state holiday just because that's the way that they do it in practice, but you're not required to do that.
But I definitely agree with Brent. If you recognize other holidays, such as Indigenous Peoples' Day or even Christmas Day, anything else, you really should consider Juneteenth and what kind of message it's sending if you choose not to recognize that date. Or at least make it one of the floating holidays, potentially, if people still have those. Okay.
It's getting better.
I know, right? 9. Oh, I love this. Well, here is one place. I mean, without being flippant, we certainly very often write employee handbooks, but it's expensive, and not a lot of small employers are able to do that right off the bat. I'm a huge proponent of having the minimal in terms of a handbook. And I've had clients who will go online, for instance, and download some big box store's handbook that you can access online and say, look, I must be covered now because they must have, these big lawyers who do all this stuff. And my response to that is that's a terrible idea for a variety of reasons. You have to be very careful about downloading and adopting anything because you may, for instance, be subject to the FMLA or not, and that handbook may say something different, and then you put yourself in a real difficult position, and it may not be Maine specific, so there's a lot of reasons why you need to start from scratch, have it apply to you specifically. But at the risk of, sending business elsewhere, I hate to do that, but there are a lot of really good HR consultants out there, and we work with several of them who can do a handbook, and maybe you have it done there initially and reviewed legally just to be sure, and so there are other options for that. But I just caution people about just taking somebody else's and saying, well, I know they do things right most of the time, so I'm just gonna take
And you never know
theirs.
what's up to date too, right?
Right.
Things change fast.
And, a lot of the ones you can find online are from other states, and so Maine might have some different laws than the other state, and they might have laws that we don't have.
Well, there
So,
may be local laws now.
Yeah.
that
so
apply.
And so many things vary in accordance with the size of the employer. Sometimes, obviously, also the industry specific.
Okay, all right. Here we go. 6. All right, internal employees apply for another position, we interview them, should the notes from the interview be added to their personnel file?
I don't know the answer, but I'm gonna put my 2 cents in, and the others correct me. I think the wording of what constitutes a personnel file in our statute is broad enough to encompass this, because it's presumably going to be talking about their capabilities and characteristics in terms of whether they're fit for that particular employment or not.
I was gonna agree.
Really?
I agree.
Right?
Brent and I worked
That's
together
all
for, 22 years now?
You've seen history.
That's all right. Seminar's over.
We have a history of not agreeing, but in this particular case, I completely agree. Does anybody disagree with that?
No, absolutely. And in fact, we've had cases where interview notes for somebody who's not the successful applicant and then later claims it was based on some form of discrimination. Those can, oftentimes be really handy for you to have to show, that they gave some lackluster answers or whatever the case might be. So I would keep them.
I do have one qualification, that even if you don't stick them in their personnel file and they go into some other binder that's not labeled personnel file, when the employee comes in and asks for a copy of their personnel file, it's in it from a metaphysical perspective.
Right.
Right.
Yeah.
I'll say something about that too, a little bit of a hobby horse, because as you know, Maine has a statute that an employee can request personnel file. It's defined functionally. And so through the years, I will have sometimes harp on my client that, it's really unlikely to be just that little skinny manila folder or one little thing that you, in your mind, think of as the personnel file. And even though it's can be a pain in the behind to have to sort of go around and collect all this other stuff, if the former employee, often it is, has a decent attorney, they'll right away be able to sniff out that the employer did not do a decent job in really giving the personnel file within the meaning of the statute. And that just helps nobody. It doesn't help the employer at all. It just creates more suspicion and likelihood that the plaintiff's attorney will think maybe there's really something here.
I totally agree. And that means if you keep FMLA requests and stuff related to them separately, you go there and you make sure the employee doesn't have anything, because if they do, that's part of the personnel file. It also means the workers' comp information. If they've got a claim, past or current, that's also part of the personnel file. And what's really important is supervisor's notes. So we've all had those situations where a supervisor has a little book, he or she carries it around all the time, they make notes in it, and you've all heard my story about one of my most fun cases for me anyway, not for the employer. Very, very, very high level employer, had 1 billion employees, the CEO calls me up on Friday afternoon and says, I can't stand working with my secretary anymore. She's on the phone all the time and I just can't tolerate it. I'm going to fire her. Is that okay? And I said, so when's the last time you addressed this with her? And he said, well, I never have, but I have a book. And in my book, I have notes from the past 2 years about all the days when I heard her on the phone and she wasn't working, and I wrote it all down. And I said, well, what did she say when you addressed it with her? Well, I haven't. So terrible idea, but all that stuff becomes part of the personnel file. So make sure that you as HR, it's your job to go around and make sure you've got supervision notes, workers' comp, FMLA, all that stuff that you store separately. And I actually had, there's a case about this too, but I actually had an employer say, well, I keep it all at home, so it's not part of the personnel file. That's just wrong on so many levels. I can't even tell you. One other thing about interviewing internally, if you are promoting somebody from a non-supervisory to a supervisory position, you have to go back and make sure that they have not only your basic sexual harassment training, but the supervisory sexual harassment training, because that statute speaks to training within a year of hire or a year of becoming a supervisor for the supervisor training. So make sure somehow that's on your radar for internal promotions. All right, back to the wheel. Number 12.
Ooh, good thing it wasn't 13.
And I haven't even repeated any of them.
I know, it's amazing.
Clarification on FMLA. Can someone take? Why, yes, they can, except what I talked about before, right, with the grandparents. Oh no, well, that's, you still can take both in 1 year, absolutely. But if they're for the same, if they're for reasons covered under state and federal, they're concurrent, right? Anybody have anything to? I mean, that's pretty.
Nope.
Well, is it automatically concurrent, or does the employer still have to take the steps?
You have to designate it. Yeah.
You know,
But I don't think, so let's say it's a medical reason that's covered under both. As long as you get the certification from the DOL, the federal forms, since Maine doesn't have any of its own forms anyway, I don't think you need to separately certify it under Maine law. But I would make sure the person knows
that it's being designated.
it's being designated as both, so that there's no dispute about what they've used and what they haven't used.
And plus the Maine is 10 weeks in 2 years.
Right.
So it may not be every year.
Yes. Documentation in FMLA is probably the most important thing about it. Okay. And I assume that for whoever offered these questions, if we don't answer it completely or you need follow-up, you'll let us know.
Again.
We've got 4.
Oh, 4. 14. Can I have a separate policy for main employment application? Yes.
So I believe that, yes, you can have a separate policy for earned paid leave and separate vacation time. You probably need to have them coordinated, but you can't have them separately. Can we say that earned paid leave will not be paid upon termination? Yes, you can say that, but you have to keep in mind that if the person's rehired within a year, then their EPL is restored. And if you don't have a separate policy, then accrued EPL will be treated the same as vacation.
But as long as they do, they can go by what their policy
Right,
says.
if you have separate policies, they can say separate things.
All right. Good. Anybody have anything? We're all good. Awesome. I think we're going to take this home for the chore chart.
Yeah.
Your chores.
We've already done 6.
We've done 6.
Have we done 6?
I don't remember these.
Bingo.
13. Uh-oh.
Oh,
You said not to
13.
land on that, and look what I did.
All right. I'll say something about this one. Who is a contractor for EEO1 reporting purposes as a CAP agency? Are we a grantee or a contractor? You're a grantee. And incidentally, grantees under the federal are not contractors under the vaccination mandate either. the employers who are required to do the EEO-1 filing are, and I refreshed my memory about this a while back, and I gotta admit I was surprised, and I shouldn't have been, but if you have 100 more employees, you just automatically have to file the EEO-1. But if that's really the only basis of your filing it, there is no penalty for not filing it. So it's not exactly one of these hotly enforced things. And then federal government prime contractors or first-tier subcontractors with both 50 or more employees and the contract amounting to $50,000 or more are required to file the EEO-1. And their failure to do so could result in adverse ramifications for your federal contract. But just being a cap agency, in fact, it would be unusual for a cap agency to also be a federal contractor. And I think you'd know it. So, makes sense?
Glad you were here to answer that. All right, we have at least time for one more, so let's see what we can come up with. I'm not sure how many are left on here anyway.
9?
Number 9, we have 9.
We've already done 9.
Oh, we did? See, what would we do without you?
Don't know.
14 we already did, didn't we?
Yeah.
What, do you want to just tell us which one we haven't done?
Okay, we haven't done 1.
There are
Look,
There we go.
One is
Look, it's on
available.
1.
Okay.
cheating, no.
Please have a language of the company. We can change the objections and deductions. I would say so you have to have a writing signed by the employee with very specific information about the terms of repayment. And I think you'd have to have the employee's agreement to change that plan in order to increase the amount before they leave, don't you guys think?
Yes, different situation once they resign though. Because at that point, then you can withhold loans from the final pay.
From the final pay, but if it
But
doesn't cover
beforehand.
it, you're still ending up trying to recoup it.
Right.
And
You
I
look
guess
like you're
my
gonna complicate
understanding,
things.
probably. But this is not a situation of where the employer accidentally overcompensated the employee.
Right.
So we're not in that the statute we were talking about earlier. This is the statute that permits certain written loans, really, advances to employees.
Right.
Right.
I'd love to restate the obvious.
That's what I'm here for, is the obvious.
I don't know if we answered that or not. I hope we did. All right, was that all of them? Did we get everything?
That is all of them, but because we are completely sneaky here, we want to let everybody know, and I'm going to go over here for 1 second.
I'm worried. Is somebody
Yeah, me
coming
too.
in? I'm worried.
We have 3 November birthdays of just the 4
Oh
attorneys.
my gosh.
So we have a special birthday treat.
Wow.
So happy birthday. Anne Marie's is tomorrow. John's was last week. And Josh's was at the beginning of the month. So
Oh my
End of the month.
gosh. Oh, well,
End of the
Brent,
month,
you don't get a
next week.
cupcake.
So happy birthday.
Well, thank
Thank you
you.
very much.
And because of COVID, nobody will be blowing
No.
up the cupcakes.
No blowing up the cupcakes. So,
Oh, that's very nice. Thank you.
so happy birthday. So you'll have to use a thingy to blow about there. Fan them away.
Light the room on fire. One of the two. Oh, that was very nice.
Yay.
All right, so we've answered all the questions, and we're at time to wrap up. We want to be respectful of your time. We really appreciate everybody joining us. We hope that you've gotten a lot out of this. We certainly will take follow-up questions by
Email.
whatever mechanism that is. Email one of us directly if you want, or to
Either Karen or
Karen.
Brooke or presentations@redmondwinchell.com.
okay. And please, please, please do take a minute to fill out the evaluation, especially if there are things you want us to do differently next year. But also feel free to say all the great things we did this year just to make us feel good. And I guess that's, were there any other?
And you will get a prize. We're gonna be
you're
giving,
gonna
we're giving
prize.
away some prizes with
Wait,
that.
how
So
do they
you make
get
sure,
this one? Is that how they get this one?
that is how they get that one. And
It
coffee.
does not have wine in it, but you still want it.
Not everybody though is a drawing, right?
I don't know. It's great. Not everybody who fills out gets one. Yes, it's a drawing. Any other final wrap-ups? I
No,
can't read that, so I don't know. That's the evaluation, right?
Yes. See you next year.
Someone's just saying thank you.
Oh, well, you're quite
Thank you
welcome.
very much.
We appreciate everybody joining us, and have a super Thanksgiving, everybody.